Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Dati mihi Anglican for each service watching.
Literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for joining us this Friday afternoon as we have a late start, a very late start for the Kouri Richins trial. The state rested yesterday and defense surprisingly rested as well, which brings us to where we are right now. And, yeah. All right, I'm excited. Oh, hello. I realized how hot it was. I have long sleeves on. All right, there was frost. I kid you not. There was frost on the ground this morning. There was ice on the vehicles overnight. I had my window open all night. I thought it felt great, but there was frost. Now it's like, I don't know, 70 degrees out there. But anyway, it is what it is. Welcome back. Happy Friday. Hope your weekend is going to, kick off with style as soon as we're done here. I hope you have a picture of this lime green roof. Hang on. Let me look at the picture I took and see how bad it is. It's just the tear off. I have a picture of the tear off. That's it. The actual... You can't see any shingles yet. I mean, you can see like people up there tearing stuff off, but that's about it. You can't see anything because it was blurry. But we'll work on it. We'll get pictures. I have not flown my drone yet because it's a little windy as well. It was a little breezy. And I'm a little nervous to go outside because there are nails all over my yard. They're running around right now with a magnet trying to pick everything up. So hopefully they get everything and I don't find them myself. But if they do happen to leave any, I know a guy with a metal detector, so we're in good shape. All right, welcome back. Hello. Metal detecting for weeks. Yay, nails. Love finding that iron. Did you have an environmental study performed before tearing your roof off? No, but I should have. Normally, like I've removed shingles before. Okay, it's not a fun job. But you get one of those little funky shovels that has a little sawtooth edge on the front, and you slide it down the roof, and you sort of pry and lift. It's not a fun job, but these guys are flying through it. And normally they just come up and sort of roll them all together, and they're sort of, if it's warm, they're sort of soft, and you sort of just roll them into a big mess, and you shove it off the roof and onto the tarp. These ones, they try to pry them up, and they just explode in a cloud of dust and probably asbestos. I don't know. They are so old and fragile and just brittle. It's been a ton of work. I'm worried they're going to raise the price on us before we're done.
There's a lawsuit.
I need a giant magnet to pick up the nails afterwards. They have one right now. It looks really cool. It looks like a broom, but it's got wheels on the end, and it's just a big long magnet. They can slide all the nails off. Just make the driveway the least nail-infested spot, and you'll be glad. Yeah. I think they're driving on a grass right now. I'm not sure what's up. But anyway, how's the plywood? Yeah, that's gonna be spendy. That's the part they couldn't tell us what it was gonna cost, and I've seen them haul too many sheets up onto the roof for it to be free. So, walking barefoot, you can find nails. Thank you for the help, Purple Coconut. I appreciate that. You were 100% right, but I would not like to do that. All right, we are about to go to court in the Kouri Richins trial. We have just a few minutes here before the feed starts. Update your tetanus shots. Yeah, just not in this shoulder. This one's sore already. Chat's not on screen. I will put chats on screen, and I will also let you know that Francis Fitzgerald was first in chat today. Congratulations. Your timeliness, your punctuality, and promptness has earned you a punishment. Everything IP related worldwide is your responsibility. Good riddance. Thank you. Thank you for taking that win for the team. Happy to hear about all the roof work. It will be great when it's done. Yes. I did not I did not tell our renter. Like, we have somebody in our Airbnb. It's a traveling nurse. She works at, I'm not sure if it's a hospital or one of the local, I think like the women's prison or something that's like half an hour that way. I forgot to tell her, oh, by the way, we're going to be running air compressors and machinery, and all the parking spaces will be taken up. So hopefully she's good with that. So we'll just let that happen. She's been at work, so I think we're good. All right. I think roofers are a lot better about cleaning up these days. I hope so. They're good. You know it's a good company when they put a sign in your yard to advertise, right? Otherwise, they just sort of just show up with like a truck with no logo on it. These guys are like bonded, insured, everything. Plus the repair, the work they did for us a year and a half ago was top notch. Anyway, let's talk about the case just a little bit. Have you considered getting a massage for your shoulder? Tell me how that would go, Josh. Tell me how that works. Ask them if they're going to use a magnet check for nails before they leave. Yes, they're doing it right now. I mean, they've been cleaning up sort of as they go, but they are using magnets out there on the lawn. Any update on the Charlie Kirk hearing? I have not been following that one. I hear that cameras are staying. Is that the update? Yeah, it was just I think a brief hearing today. I was not sure. Let's talk about the what ifs, Cindy. Let's talk on the what ifs in this case. I'm thinking the jury is hung. Oh my goodness. If the jury is hung, then we rinse, wash, and repeat, and we get to redo this probably in the next 90 days. However long it takes to seat another jury and find a slot in the docket. And we start over from scratch. Most probably we start over from the last thing we did before we picked the jury. That's where we're going to restart. Is the roof tiles white or light gray? They don't look bad to me. I've only seen a little piece of it as it fell off the roof, and I think that was one of the new shingles. I'm hoping it's one of the new shingles. It looks like it's like one of those, it's a black shingle that has white flecks on it and a little bit of green. We'll get a picture when it's all done, and you guys can be the judge. We'll do the gray dress debate on internet right here. Purple Sunset Lover member for 27 months. Happy Friday. OG Purple Sunset Lover. Thank you very much. You cut your hairs. Hey, my wife did that for me. She cut almost all of them. I think there are a couple that somehow escaped. I'll find them and probably pluck them out. But yes, she said, I'm cutting hair today. You want to be first? And I said, yes. If we follow Tyler, I can see me getting sent to the corner to the point I'll lose my courthouse for good. So they will podcast. No, you'd be great. The audio for that courtroom is terrible. The Tyler one? Cameras are in. It's going to get better for Tyler. I can promise you it's going to get better. Usually, for these little hearings, it's different. The media in the courtroom is not given the access and the time to set up that is given before a big trial. In a big trial, the judge or the courtroom personnel meet with the pool media, say, okay, here's what you need to set up. Here's where we're going to allow it. Here's when you can come in. This is all the hookups. It should be better. Should be better for the trial. Question: if Kouri is found not guilty of this crime, she could still be guilty of second-degree felony charges of insurance fraud and third-degree felony forgery. Yes. None of these charges are dependent on any other. So in theory, she could be found not guilty of any or all of these charges and found guilty of any or all of these charges. If she's found not guilty, she still has her other case coming up.
Hey, Wall.
Hey, Wall. How are you doing, my friend?
Hey, what's up, Scott? How you doing today?
Happy Friday. I'm doing well.
Happy Friday. Just wanted to call in. I don't do the birthday shout-outs, but mine was yesterday.
Hey, Wall.
And
we even talked yesterday.
Yeah, no, I don't celebrate my birthday like that. I feel it's a little
We celebrate
cocky.
Your birthday. That's what we do here.
I don't mind celebrating other people's birthdays. I feel like I feel like it's like seeking praise. Personally, my opinion.
Hey, I have no shame. Mine's on the 24th. You've got 11 days to think of a good gift. So
I think my gift is, and thank you to chat. Thank you for you, RA, for doing this since Darryl Brooks, and I appreciate it. I appreciate chat, and I have a gift every day, so
That's
I'm blessed.
awesome. That is wonderful. Hey, well,
So-
what's on your mind? You didn't call to talk birthdays, I'm sure, but happy birthday anyway.
No, that's really what I called, just to give you thank you for the gift of streaming.
Oh, man.
And doing what you do. It's not easy. It's
Appreciate
long
the kind
hours.
words.
And your family has to do it too, and they appreciate it. I can see it, the love in the family. I like it. They're all on board. And that's it. I just called to say I appreciate you, man. And chat.
And chat. And even the mods,
And the mods, especially the mods.
Well, AWOL, thank you for the kind words. I know that a lot of that praise is not deserved, because I know it was other people's hard work that made this possible, and just amazing people in chat that makes the community what it is and makes it as welcoming, and incredible mods that carry the lion's share of some of the burden of just running this whole thing every day. So I'll take the praise on their behalf.
But every ship needs a captain.
Thank you. I
And that's
appreciate
you.
that.
So there goes that. So thank you. Just called to say that. Keep doing you, and mad love for everybody.
Hey, well, thank you very much. Have yourself a great weekend.
Yes, sir.
All right. Bye-bye.
Bye.
What a stud. What a great guy. All right. Doesn't tell us about his birthday. Who? Hey, well, we're putting you in the birthday list for next year. We're going to sneak up and get you. All right. Let's see. I just logged on. I can immediately tell who it was. AWOL, love your takes. Yes, we have lots of AWOL fans in chat. I like him as well. He really makes me think. Challenges my opinion sometimes. Not my patience so much as my opinion. And I like that. I like somebody who can present an argument in a way that makes me stop and think in a way that I might have not done before. So, all right. Let's see.
Happy birthday. You look good.
Can you call in the Discord? Sure. Let me pull up Discord real quick for you. You've got the link, right? Or do you need that again? Discord. International calls. All right, I'm ready when you are. There's the link for international viewers. Just saw the same lawyer in the Charlie Kirk case. Yes, that's Miss Nestor, and now she's racing back to Summit County to start here. Katrina in Discord. How are you doing, Katrina?
Oh, I'm not doing bad. You?
I'm doing absolutely fabulous. What's on your mind?
I just wanted to run something by you because I've been thinking about the defense yesterday. With the motion for I don't remember his name, Norris something. I don't remember
who said Chuck that. Norris. It was somebody else that's in Norris.
Norris, that is not associated with Chuck, but
right. David Norris.
And I was thinking that could it have been that they were waiting, like hoping that the motion would go through and they'd be allowed to bring it in, and that would be their case. And then when they heard what the judge found in the case law, we're like, oh, this will just be way worse for us. So maybe that's a terrible idea. And so they were thinking that maybe it would be a better idea just to leave it and rest their case.
I think you're right.
And then they were conferring to be like, oh, are we sure we don't want to do anything? Okay. And then.
Yeah, I think you're right. I think you're onto something. Obviously, if they had gotten permission from the judge to go ahead and say, by the way, Detective O'Driscoll, is it true that somebody came up to you and said, hey, I heard about this case. Eric came to me and tried to buy fentanyl. Is that true? Did that happen? It did. Did you look into that? No, they didn't. At least not the way that they would investigate another tip that was more credible. But if she could present it in the way that she wanted to and bring it in, she would have preferred to do it, I think, on cross-examination, first of all, because you can lead. That's much easier to get to that point. But if it wasn't allowed that way and was allowed in their case in chief, I think they would have presented it maybe as their only evidence and then closed. That was a gold mine for them if they could get that in. That's huge. That's huge.
Yeah. Though I think what the prosecution had.
Uh-oh. Somebody called and cut you off. Hang on.
Bad. Honestly, it's for me with that, I'm definitely in guilty. So I'm kind of undecided based on what the jury has. But with that, I would definitely kind of like be pushed over to the guilty side. So I think they were just like, the cost analysis is maybe just, it's too risky.
Yeah. Great thought. Where are you calling from as far as what part of the world?
Montreal.
How's the weather up there?
Yeah. Well, it's been a bit iffy the past couple of days. We had a lot of rain. So, and then there was a lot of ice, so people lost power. But,
some people got 8 inches of snow yesterday, expecting 10 to 30 inches more. So count yourself lucky. But love having the Canadians from the true north. Is it bold and free or strong and free? How's the song go? Oh, Canada, my home and native land. It's not really, but I've sung the song a lot.
Yeah, I'm not.
You don't know your national anthem. What?
I know. Like, I'm just going through the whole thing to try and remember what it is.
Strong and free.
Yeah, it's True North, strong and free. Yeah.
There you go. Thank you, Allison.
Yeah.
Allison sung that a few times as well. I happen to know because I sung with her. All right. Thank you very much for the call. I appreciate it. And thanks for checking in on Discord.
Yeah, thanks for letting me.
Not a problem. Anytime.
Do my thoughts, I guess. Thanks.
Anytime.
Bye.
We'll see you. Bye. All right, we had one other person who was trying to call in as well, and I unceremoniously hung up on you. Please call back. That would be great. Shelly Small gifted 5 memberships. Thank you, Shelly. Congratulations to the recipients. It's because they keep changing the lyrics on us. Really? I did not know that. I didn't know they kept changing them. That's going to be harder to remember. Here we go.
Call from Jacqueline.
Hello, Jacqueline. This is R.A. How are you doing?
Hey, I'm good. How are you?
I am good. Are you ready for court today? You have your popcorn?
I am. Yes, absolutely. Yeah, actually, I'm covered up in a blanket right now. We're just waiting. I did have something I wanted to bring up, though, and I don't know if anybody else caught on to this.
What's that?
But there was a voice on the 911 call in the background, a female voice, not Kouri, somebody else. Was that ever mentioned? Who was there with her?
I remember this call, and I remember a couple things. First of all, when someone showed up on the scene before 911 expected someone to be there, and we believe it was an off-duty or an on-duty firefighter who drove in his private vehicle who got there first. So the first voice, the adult we hear, where she says, he's in here, and she starts saying, he's in here this way. Right after she says it's open, it's in here, right back here, this room, those sort of conversation. That was the person who showed up and took over CPR.
I got it. Okay.
There was another voice, but when the dispatcher is taking the call from Kouri Reed, she's inputting information in the computer, and another dispatcher is either dispatching people to that call or someone else. We're hearing a voice on the dispatch side as well that's not the caller, not the call taker. It's a fellow dispatcher, and she's sending out the stuff to the police officers. So there are a couple voices at the same time. I didn't hear anyone else other than that. It would be interesting if there was somebody else in the house, but we haven't heard any testimony that anyone other than the kids was there at that time.
Yeah, and that's why I was kind of trying to think back, I don't know. It sounded like another female voice, and I wasn't sure, was her mom there before? And, I don't know. So I don't think it was ever really clear who that other person was, but just something that I've been thinking about as this whole thing has kind of played out. So
some other people are saying there was a female voice you heard on Kouri's end. We'll have to maybe go back and listen to that. I don't remember what day that was, but for me, and I was listening with the headphones on, so I'm pretty good. I've done a lot of listening to dispatchers and police traffic, so I'm really good at picking out voices that are dispatched. I didn't hear anyone that seemed to be on Kouri's side, other than that gentleman, the man that showed up to help do CPR. But we can. Yeah.
To me, it was a female voice, but I mean, I could be wrong. But if we could go back and listen to that, I think that would be interesting. Like I said, that never got brought up during the case, so kind of. I'm not really sure. But yeah, definitely something to kind of look into. And I don't know that the prosecution noticed that or thought it was relevant either, since they didn't bring it out. But
I think it would definitely be relevant. But yeah, we'll see if we can take a look look for that. Apparently, while I was on the phone with you, I called her Kouri Reed.
Yeah,
which
you
is
did.
which is
And I was
half
actually-
between Karen Richins and Kouri Reed, so we could flop these two around. Karen Reed,
Yeah.
Kouri Richins, that's the right way. The two KR trials back to back, big ones. It just fuddles my brain. So,
Yeah.
But the good news is, if I mess up the names, they can't sue me for defamation of character, because it's like, well, clearly it wasn't you I was talking about.
Yeah. Yeah. One was acquitted, and one not so sure she's
We'll
gonna
see.
gonna have
It
that
could
same
happen.
road. But
It could happen. So.
yeah, it'll be very interesting. So, looking forward to it, but kind of sad they didn't put on a defense. I don't know if that was a good strategy or not, but I guess the jury will tell us.
I've been thinking about that a little bit. There was so much bluffing and posturing, and there's a little bit for that, but the state just had a solid case. They weren't shaking them. They didn't change anything. It's like, who are you showing off for? Who are you puffing up for? I don't get it. I don't get it. Even at the last minute, when the states rested their case, they're still like, Your Honor, we're still weighing the options. And Kouri's like, well, what? I thought we weren't putting on a case.
She looks surprised. Yeah.
Yeah. Interesting. Yeah. Great thought, though. I'm not sure if we're going to be able to listen to it before court today, because it takes a while for me to dig things up and get it ready, but I might do it tonight.
Yeah, I was trying to think what witness it came in through, but I honestly cannot remember. One other thing I wanted to mention, that just real quick, I think it's very interesting that, I've always been one of those types of people that if you don't have anything to hide, like, don't delete your stuff. I think it's very interesting that the text messages and all of that, even the gifts and all of that, Kouri got rid of those, and they were sent by Eric. Like, I just don't understand why she would have deleted relevant things that were good for her in the moment. Maybe she clearly just wasn't thinking, but I don't know why you would delete things like that. But
that brings up an interesting thought for me, and maybe this is why we tie things back to the Karen Reed trial a little bit. But in the Karen Reed trial, the depth that the experts went into in the phones, and the how they work, the deep where the files are stored and how it saves it and when it writes, when it saves, that was deep. That was a deep dive, the deepest we've ever seen. I sort of think we could have benefited from that in this trial, because we're sitting here looking at a printout that tells us that she looked at like 6 different pictures at the exact same second. And we know that didn't happen, right? It's just, no one can, you can't Google that fast. It just doesn't work. And so I wish somebody would come in and be able to explain and say, hey, this was actually her phone accessing a text exchange. Then it loaded the past 30 days so you can scroll through. And when it did that, it put it in like a buffer file. And so when it loaded all those, they appeared there all at the same time when it loaded. But she wasn't actually looking at it. Those might have been deleted messages from who knows when, right? But she loaded it, deleted it maybe, and then this saved file, this ghost file remains. So I wish we got that extra information. In my head, I think that's what happened. But it would have been nice to hear from an expert who really knows.
Right. I totally agree with that. Well, thanks for taking my call. I'm
Anytime.
a huge fan of the channel, and I've been
Thank you
listening
so
for a
much.
long time. I think I've been a member for 8 months, but great job.
Thank you so much.
For everything that
Appreciate
you
it.
do. Thank you.
All right. Have a good
All
one.
right.
We'll see you.
I'll be watching. Thanks, y'all.
Bye. All right, they're just bouncing the cameras right now. We're getting a feed in just a second, so we'll get that pulled up for you. Another call coming in. Just 1 second.
Call from.
Oh, hello. I cut off your name. Who's calling? This is Scott. Hello.
Oh, this is Debbie.
Hey, how are you doing,
I've
Debbie?
got to turn you off.
Turn the TV down. The delay would get a little confusing. It's just a couple seconds.
That's where I'm going.
But
Okay, okay.
How are you doing?
A quick one I'm doing fine. With the phone calls, Kouri and Bryce, in that phone call where she's so whiny, did you notice how when the kids showed up, she all of a sudden went back to normal mom? She was impatient with them a little bit, but she was trying to shoo the kids out of the way. But it was an entirely different demeanor from when she was talking to Bryce. Now, I'm not a mom, but when as a person, I had never been that whiny, But I would think that someone getting that whiny, so high pitched, so emotional and weepy, to all of a sudden drop all of that to be nice to the kids.
Yeah, it shows that it's an act, right? That this isn't an
authentic,
mental state that you're in. It's hard to turn off, certain feelings like that, and then on and off. Those don't happen exactly like that. But
that's the point I wanted. Thank you.
All right, we'll see you. Thank you very much. Okay, we're just getting all the recorders going. Started Top Mark Media. I'm sorry. I completely botched the goodbye on that phone call. I do apologize. I appreciate your call. Thank you so much. That was a great thought. Sassy Nana, so great. I get to catch a live in on the Rewatch Crew all week. We are finally on a live. The late start helped, I think. Sloth Life, member for 26 months. OG. Naked messages, FU trees, and spamming spam callers. I thought I joined the trial watching channel. RA members only streams have a whole new meaning. Okay. Yeah, about that. The podcast was great last night. Hope you guys enjoyed it. If you missed it, you should watch on the rewatch. Let's see. I'm trying to talk over the air compressor and the banging on the roof. Let's see. You're definitely not the only streamer who has flubbed her name. I know, but I do it consistently. Like, I should know better by now. I'm terrible with names. I do apologize. Kouri, Darden, Richins. I'll remember that. Am I blurry? I'm in focus now. Just change the depth of field a little bit. All right, let's see. It was in the transcript as unidentified woman. I think it was her mom. Oh, wow. I missed that if it was in the transcript. We will have to look. Really quickly in chat, what witness was it that was brought in on? Someone's about to get a whooping.
I think I'm about to catch a whooping.
For RA for making me buy so many snacks today. I'm sorry, Laura. I really am. Let's see. Ivan, hello. Ivan, you've typed your name in such a way that nobody can tag you. It's, you've gone full ANSI characters on us. They played the 911 call in between witnesses. It was near the end of the state's case in chief, I think, the whole call, right?
Call from
Atticus.
Atticus, this is Scott. How are you doing?
Hey, buddy. I know they're about to go live soon, so I'll be quick.
Sure.
I'll take them in reverse order.
Okay.
First of all, you used to be a gamer, and I didn't even think of her initials being KDR. That's actually kind of cool. You know what that stands for in the gaming world?
The kill to death ratio?
Yeah, buddy.
I haven't lost it yet. I was never a Counter-Strike sort of guy or, any of the first-person shooters as much. So the KD ratio was not
and then
interesting.
The last caller was talking about how she changed her demeanor and all that.
Mm-hmm.
I know what she's talking about, but as a parent, you kind of go into, like, for me, like, I would totally go straight into dad mode to be strong for them, not to, because kids aren't dumb. They know when you're emotional and you're hurting.
Yeah.
But at the same time, I would totally just go into dad mode and act strong.
Yeah. I would say that we definitely got the feel that call, that whiny call, was an act. We know Kouri was recording it, right? She had, like, her phone out filming a video with the other phone on speaker so she could record this. So this was, she knew, she's like, I'm trying to get something out of this from Bryce.
Yeah, and that was when she was with her friend, right?
Yeah. Yeah.
Yeah, and you could tell that they were definitely, drinking was definitely involved.
Yes, I think that was commonly a problem.
Then the third one was, the 911 call.
Mm-hmm.
The last time they played it, the really long one, there was a point where the kids almost, like, walked in. You remember that? Like, maybe that could have been like a little kid's voice, even if it's a boy.
There was a point where
definitely sound like a girl.
It was right around the time she was supposed to be pulling Eric's body off the bed.
Yes, exactly.
And they were trying to walk her through how CPR is supposed to work. And
yeah,
she's like, go out, go back to the room, go to your room.
Yeah.
Yeah, I didn't hear the kid's voice in that one, but
Yeah, neither did I. I was just guessing.
But it could be. We'll have to go back and listen now that we've got something to listen for. There's a lot of noise
Right.
there, but excellent idea, Atticus. Thank you very much, and you fit it all in before the judge started talking, so that's a win-win.
Incredible. All right, buddy. I'll talk to you later.
Thanks. Bye. All right. I called my insurance today. I'm like, I'm not sure if you care, but I'm getting a new roof on my house, and I'm leaving a message for them because they go home at 1 on a Friday, like all sane people should. And I'm leaving a message, and then I realized, like, halfway through the message, they probably think I'm calling to make a claim. So I'm like trying to clarify. It's like, this isn't a claim. This is like, we're just doing the upgrade on our own. It needed it. We probably should have done a claim. I'm sitting on the phone. It's like, how do I delete this message and start over? Never mind. Jay Down says, for me, the journal entries where she does a play-by-play of her responses to Eric's death really sealed it for me. This is the orange notebook. It doesn't jive with 911 call and body cam and just feels manufactured. I can see in the orange notebook that possibly her lawyer, which she did, I think she consulted legal pretty early on, or at least talked to somebody who had some experience. Somebody probably recommended that she writes everything down so she can remember it. It was probably for her lawsuit against Katie that she's trying to write everything down. I think more to protect herself. It was a woman's voice. We're going to have to go back and listen to that. We might do it over the weekend, or I might pull it up over the weekend, get it ready for Monday. Who's making an egg salad sandwich? Making an egg salad sandwich for lunch. Yum. I love egg salad sandwiches. The only problem is when I want one, usually the eggs aren't boiled yet. Who has 10 minutes to wait? I don't have 10 minutes to wait. Laura says, I'm explaining it terribly, but the lack of exertion we heard on the 911 call, it's what makes me think there was no CPR attempt. Also, just the amount of time it took for her to get him on the ground, and there was nothing. I mean, there was she might have done some presses, but no one's going to be revived with the effort that she was putting in, assuming she was. Just made pineapple upside down cake for Lee's birthday. Sorry, guys, I don't think he'll share. Yum. I had a comment, but I can't share it. I didn't even hear a thud. I heard the thud, Johnny. If you go back, you can hear it. I had to go back and listen carefully. That was one thing I did listen for in the call. It didn't sound extremely loud. Like I was expecting there to be more of a thump. It was more like like something like this. Well, without the spring sound. Like that. But I heard the point, and I guess we could probably time from there until when somebody came in. But I'd be surprised if it was more than a minute before somebody showed up. And the dispatch starts asking about, is the front door unlocked? I think as soon as they said, is the front door unlocked, Kouri stopped what she was doing and ran to the front door. She was not interested in doing CPR, I think, at that moment. All right. Anything else? Let me pin this message. Thank you, Josh, for that. We are on day 14 of this trial. Day 14. Today is not a testimony day in court. We're done with that. We've closed that chapter of the trial. Today we're going to have both sides possibly fighting over or agreeing upon the juror instructions, and maybe talking a little bit about what closing arguments will look like as far as scheduling, as far as time limits. If you remember the openings, Mr. Bloodworth, was he an hour and a half, and Ms. Nestor went 3 hours or something? She's a talker, so I imagine she's going to probably want to talk a lot as well, because they don't have a case other than her talking. Let's see, currently watching a pair of bluebirds making a nest in the birdhouse my husband built for me. The pair is the same from last year. That's awesome.
Remember in the beginning when we started 110 years ago?
It seemed like she talked for 110 years. Let's see. It was a shoe drop. I think he was dying when he hit the floor. They testified about his body askew when they came in. Miss Nestor's closing arguments will go 7 hours. Oh, that is cruel and unusual. That's cruel and unusual torture, punishment. That is so bad. 7 hours on a closing for a case this long, I don't think. No. Please no. Judy V, welcome to the gallery. Thanks for your continued support. Got that second month clerk courthouse. I thought the female paramedics said his body was laying abnormally straight. I just remember he was on his back on the floor when they got there. Friday the 13th today. Anyone getting discounted tattoo? Is that a thing? Is it like cheap tattoos on Friday the 13th? I got married on a Friday the 13th. I didn't think it was unlucky. I think it's one of the better decisions I've made in life. I thought charge conference was done in private. I think it's going to do open. I think it's going to be open in front open court. Judge will more than likely put a time limit on the closings. I think if we are... What time did the Tyler Robinson hearing end? Does anybody know? Was it just before we went live, or was it earlier this morning? Because she still might be driving up. 30 minutes ago. Okay, it's at least a 30-minute drive from Salt Lake County to Summit County Courthouse. That's assuming you don't have traffic going up Parley's Canyon. She might be 15 minutes late. If she gets there in less than 15 minutes, she was speeding. I'm going to call that. Nestor was on WebEx. Oh, okay. That fixes it. I thought she was there in person. For those that watched the Tyler Robinson hearing, was it just the media? I didn't get a chance to watch it. I was working on some other stuff. Was it just the media arguments that they heard? Yes, there's cheap tattoos on Friday the 13th. Watch the podcast just for the massage story alone. It happens, okay? I share my life with you. That's... Don't allow Utahns speed. I hear they can be wild drivers. I would say, having moved from Utah to North Carolina, the drivers in the Triangle area, and by drivers I'm talking about the bad ones, not the good ones, but the bad drivers in the Triangle area of North Carolina are much worse than the bad drivers I was familiar with in Utah. Utah, we had a lot more traffic than we do out here. So there were a lot of cars on the road, and there was a lot more traffic jams. So when the rush hour hits, everyone's trying to rush and beat the rush hour, because rush hour hits and the freeway just slows to a crawl for an hour and a half, and it should have taken 10 minutes to get through. So that's bad. And then when there's an accident, it's even worse. It's usually what causes it. But here, I would say we have much more aggressive drivers that speed at higher speed. So, over 100 in traffic here, whereas everyone speeds, 5 over, maybe 10 over in Utah. Not everyone, obviously, but the majority of people. That was my experience anyway. I-15, 215, I-80, all those fun roads. Anything between Salt Lake City and Wendover, that doesn't count. You can't count as, the speed that people drive to the casino or back against them, because It's only like 10 minutes away at 210 miles an hour, right? The faster you go, the quicker you get there. And that's the weekend party spot for a lot of people. That's like, how far is that? It's not 10 minutes away at 210 miles an hour. It's more than 10 minutes. Do you think she's guilty or not guilty? Nylet, I'm leaning back towards guilty. And by leaning, I'm saying I think the circumstantial evidence is strong enough to convict. And I want to hear the state spell it out. I want to hear the defense argue their side. Not because it changes anything, but I want to just make sure I've considered everything. Hey, how's it going? I haven't heard him, if he did. Yeah. Do you remember the weird tree thing on the way to Wendover? I guess it's art. It's just one more thing you pass before you get there. Robinson's hearing today was 4 motions. 3 were related to stuff the defense wants to hide. They were denied. 1 was the media motion, which judge seems to lean in favor of transparency. Yay! Thank you. Okay, I've got a friend who lives up here. He used to live near me, and now he lives in Raleigh. But he's from South Carolina. His family's from South Carolina, and we went driving on a trip. Actually, to South Carolina together. He came with us on a trip to help with the hurricane cleanup. So we were, taking chainsaws and everything, cutting down trees and stuff. So he was driving, I was in his car. And this guy is the most chill, calm person. I mean, I don't think he ever gets his blood pressure over the recommended resting level. He's just that calm of a guy, and he's funny, and he's just nice, and just always smiling. And he drives like he's in NASCAR, but he does it with this calm, no sudden movements, no tense muscles. And every commute, you tuck in, you get the draft, you brush the bumpers, and I am just like a ball of just like, oh my goodness, we're gonna crash. Hey, how are you doing? You need me? What happened?
Well, there's a guy who's gonna come and he's gonna ask a lot of questions and say, hey,
is he here?
You sign this stuff, and I don't want to be that person.
No, don't sign anything.
I don't want to sign anything. I want him to talk to you because you're the guy.
Okay, let him know that you don't have the power of attorney to sign. Is he here?
Yeah, he'll be here in like 1 minute.
Oh. Court's about to start.
Great.
He's here. I've got a guy who's doing a bid. I've told you about the roof. Have I told you about our steps to our house?
It kind of sounds like he wants to do like a pitch.
It's the guy I told no. I promise you.
Okay.
It's the same company. Yeah. Okay, I'll talk to him as soon as he gets here. Okay. What that means is I'm gonna have to step away as soon as the guy gets here and tell him he's trying. It's the same company that I told no.
It's not.
I promise you. Anyway, we're fixing the roof. We also have decided that our front steps are going to kill someone, and at that point, we have to say, could we fix them? We were hoping. We have front steps that go up to a large patio area. We were hoping that somebody could come and drill a little hole and like squirt that expanding foam down in there and sort of lift them back up. Apparently, that's not a thing for steps because it would like squirt out the sides and not lift the steps. But might need them to like demolish them, tear them out, and build them again, new concrete, which is not fun. Sounds expensive, but he's going to be here. Music is my bestie, 88. Welcome to the gallery. Thank you very much. Appreciate your support. I don't need a lawsuit. Yes, this is my rationale. That person's pulling a Kouri. Don't sign anything. Her meds was found in his system. Mrs. R.A. can babysit us. You have to tell her to be quiet during court. She can't talk over the judge. And she'll have a lot of questions because she hasn't followed the whole thing. Thank you for the notice. I've got mail. I will run and get that. It's closed today, but I'll get that on Monday when it next opens up. Home is beautiful. From a distance, it looks great. Dispatch Debbie. It looks great. Why did you change the station's background? Which one? Which background are we talking about, Cindy? Hey, Jen, you want to swap and take a seat in here when he gets here? Oh, okay. I'll just run. Okay, we have sounds off. I'm gonna turn the mic off. Court is live. This is a live feed. We've got audio turned on right now from court. So as soon as this starts, you're gonna hear it, and I'll be back in just a moment as soon as I can talk to this. Be nice. I'll be nice. I promise. I'll have a story as soon as I come back. Maybe a picture. 1 second.
You love Ari's home renovations. That makes one of us. Can you hear me? No, you cannot. Can you hear me now? Which mic is me? All right. I have no idea. Okay, can you hear me now? Okay. Oh, that. I was like, it doesn't make any sense. I don't know why he has these headphones on at all because I can't hear myself in them. That's because you couldn't hear me either. Okay, I figured it out. First, number 1 slide. That's the one that affects whether or not you can hear me. Okay, awesome. Press the flashing yellow button. Greeners? Greeners, I just don't think I trust you. Yeah, thank goodness it's Friday. Do you guys, okay, so here's the deal. Can you see me? Scott is significantly taller than I am. Daylight savings has kicked my trash, and I have a plan, right? I have a way of dealing with daylight savings, and it is just grab the bull by the horns. This is how we're going to deal with this, and I wake up at 5:30, and I just stay awake all day long, and it should take about 2 days. And as long as I don't take any naps and I wake up at 5:30, then my body will absolutely crash and adjust to the new timetable. It didn't. Aging, my body did not adjust, and it did not adjust, and it did not adjust, and I just was so tired. And I had my pathway meeting at 7 a.m. in the morning, and I was like, I am so tired. But it worked out because I kind of was a zombie all day Thursday, and then at the end of Thursday, my body snapped and said, I've had it with this. It was 8 p.m. I laid down, and I did not get up again until 6 a.m. And I was like, okay, there we go. Now we're cooking with fire. That's good. You're still struggling with daylight savings. It's legit. This is a horrible idea. Can we please get rid of this awful experience for all of us? It's funny, your voice's cadence is much like Mr. R.A.'s. I think that's because we've lived together for so long, because when we first met, he had a different rhythm to the way that he spoke, and I was much more, I was just more. In all the ways, I was more, and now it's not so bad. Now I'm a little bit more mellowed out. I hate Friday the 13th, and I hate daylight savings time. I actually got married on a Friday the 13th. It's not so bad. It's for real. I struggle enough without it as it is without daylight savings. Yes, this is so true. Are you needing me? Are you all just watching to see what I do if I have the microphone? Okay. I have an audience, guys. It is true. Yeah, I can hear when somebody's from Utah. Actually, because I have lived in the South for a while now, I can hear when people are from the like Oregon, Washington area, and I can hear when people are from the Utah, Colorado area, and I can hear different types of Southern twang. I can't imitate all of them, but I can hear the difference now. Red Pen says hi to all of you. All of you. Are you hiding from the guy? Is that what's happening? You're in here hiding? He's in here talking to Dad.
No, he's outside.
Oh, Dad did not let him in the house. Good. I don't mind him. I don't like being pitched, and so it's fine. What? You have Chris Martin of Coldplay, grandfather, to blame for daylight savings. If you don't believe me, check it out. Jan, is that for real? Does everyone just want to sleep? I hate it. Yes, yes, we all just want to sleep. That is exactly what's happening. So just how green is the roof? I've got to say, not as bad as it looked. When I first got here, I saw the package of shingles, and I had gone shopping first thing in the morning, and so I saw these on the floor, and I was like, oh, they're green. They're like moss green. Like, I mean, people pay a lot of money to get the moss off, and it looks like we're putting it on, and I didn't love it, but Scott was like, it's too late. They're here. They're putting it up. We just have to make it work. Well, they were sitting on our red brick patio area, and so it's possible that they just looked green. I don't know. But when I was driving in I just got back from the library, and as I was coming up, I was like, I can't really tell if that's the new shingles or the old shingles. So either they're still the old shingles that they haven't taken off and those look fine, or they're the new ones and they look fine. Either way, at some point, our shingles looked fine. All right, said lime green. Yeah, that's Scott. In Ohio, they want to keep it on daylight savings time all year round. Well, let's move to Ohio. I don't even care if it's daylight savings or the non-daylight savings. I don't care. That's a guy. Hey, guys, which one? Which one do I do? Okay, go tell Dad that the judge is coming back, and I don't know which button to push. Stop laughing. Go get Dad. This is harder than it looks, guys. It's one of those buttons. Thank you. Just start hitting buttons. What could go wrong? The court sound button. Oh, you guys are so helpful. The camera will change. I don't think you have to do anything. Just shut up. I hear this a lot. Unplug and replug it all. Okay, nice. Ari said it's live, so the sound will just go. Well, that would be sweet. That would be really amazing if that happened. Oh, you know what? And I think that's right, because they actually have it muted on their side. I did come in and start touching some dials, but it'll be fine. Just relax. What? Red? What is this relax you speak of? Red Pen trying to talk me off of the edge here. Deep breaths. Press the 56th button. Hang on. 1, 2. Okay. Awesome. Sorry. So is everybody else, the volume's really low on me? Or is it stop laughing? All slides up. Just all of them. Just do it all up. He left the sound on, he said. Okay. But don't press the red one. You guys, I want you on my team. If we're ever in like a hugely stressful moment, you know what to do. Okay. We have so much fun. Well, I'm glad. Your volume's fine. Turn it up to 11. Awesome. It's fine. Don't touch it. That's funny. Okay. Just turn the big knob. You guys, you think you're funny, but there are big knobs here. There are things I could turn. There are red buttons I could push. Things could blow up in other countries depending on how I handle this. I'm in New York. Hang on. You're moving really fast. I'm in New York, and I want to keep daylight savings time, too. Are you guys saying, when you say you want to keep daylight savings, are you saying, let's just leave it like it is and never change it? Because that's fine. I don't care one way or the other, but let's just stop changing because it's not worth it. Even the benefit that I get in the fall, I don't care. By the time spring comes and I have to go through this really painful change, I just don't want to play anymore. I'm not nice, and it's not safe for people around me. And stop nodding. Stop nodding. There are 3 buttons you have to press simultaneously. Just try some. Let's just practice a little bit. Dad says don't push anything. That's excellent advice, pretty much always. Okay, yay, Mrs. R.A. Thank you, Janabelle? That's a cool name.
1500139, State of Utah versus Kouri Richins. Counsel for the state, Mr. Bloodworth and Mr. Burmester in the courtroom. In the courtroom is Ms. Nestor with defendant, Kouri Richins. Participating via WebEx are Ms. Lewis and Mr. Ramos. Let me just provide a little context for where we are at the moment. I have given an honest try to updating the previous proposed set of jury instructions to reflect some events that occurred during trial, to reflect some, though not all, yet, of defendants' proposals received by the court this morning. I've also provided a working copy of a proposed verdict form. This will be an iterative process. We need to go page by page. I expect I'll need to take breaks from time to time to consider the substance of your arguments. Let's just take it one step at a time. Mr. Bloodworth, Mr. Burmester, anything general before we begin?
No, nothing general.
Ms. Nestor?
No, Your Honor.
All right. So, may we go by page number, working off of the draft that the court just provided to counsel. Pages 1 through 14 are the opening instructions that the court gave prior to opening statements.
Right.
Yes.
Any objection to including those in the closing instructions, Mr. Burmester?
No.
Okay. Ms. Nestor?
You want to reread them?
No.
Oh, good.
I'll start reading at page 15.
Oh, great.
But
I have no objections to them going back.
recent appellate decisions have chastised district court judges for not including them in the final set. So.
No problem.
Okay. Pages 15 through 23 are Muji second standard instructions without modification that were also part of the party's proposed instructions submitted prior to trial beginning. Take a moment.
No objection from the state?
No objection from the defense.
Okay. Ms. Nestor, pages 24 to 25 is the substance, I think, or is a Muji standard instruction regarding in-custody informants. It would require maybe a little editing to remove some unneeded syntax.
Mm-hmm.
So first, I need to hear from the state about whether they have a general objection. And second, we need to make this specific, if it were given, to the time periods that Ms. Lauber was actually in custody and the evidence regarding those periods, because she's not in custody during the time she's on the stand.
Right.
Your Honor, the state objects to this instruction because this is for a snitch. She's not a snitch. It's a different circumstance. Now, the defense has proposed an instruction.
From the 10th Circuit?
Right.
Yes.
State, yeah.
Garcia.
Right.
Instruction, which seems more nuanced for the circumstance that we're talking about. So if we have to have one, then that would be the one we would prefer, rather than this snitch instruction.
I looked at the case that is the genesis of this. That informant was in custody at the time of trial. and came from jail to trial and from trial back to jail. And so I recognize that this case isn't that.
The other thing is, Your Honor, the witness credibility instruction number 20 from page 22 allows both parties to argue whatever they need to under this circumstance. I mean, the unique thing is there is the idea that she was given immunity, or the testimony about immunity, as well as for Crozier. So that all is great for argument, but I don't know that we need any special instruction, given that neither person was in custody at the time they testified.
Ms. Nestor.
Your Honor, I think case law is really clear that witnesses who are either granted immunity or are bargaining in a jail setting for their own freedom when they give information, which is the circumstance with Ms. Lauber, are a special category of witness. There are things that a jury can take into consideration that exceed what is contained in the normal witness credibility instruction. In this particular case, while I agree there may be some editing we need to do on the in-custody informant, I think the importance of this is she was making a statement with the understanding that, that her freedom was contingent on it. And I think that this is an approved Muji instruction. I think I agree we should probably limit it. When I submitted it, I was thinking all her interviews, she was in custody. But I didn't think about the fact that she's no longer in custody. I never really looked at this instruction that way. I always looked at it as of the time that they cut the deal. But I could be wrong about that. So I don't have an objection to adding dates that she was in custody, if that is of concern to the court. I do think she made it pretty clear when she was here she wasn't. So I think the jury knows she's not currently in custody, but I mean, it doesn't matter. I'm fine putting those dates in. But I think the immunity one should be given in addition to this, because the immunity agreement also covers federal immunity, state immunity. Yeah. I think we should get both. And we can just take out whatever on this in custody informant doesn't fit our facts. We can just jettison it. But we are asking for both.
Mr. Burmester.
Your Honor, a couple of things. First of all, if we're going to identify a witness by name, it should include all of them that come within the definition. So it's not just Carmen Lauber. It should be Crozier.
The periods during which Mr. Crozier was giving the interviews, he was in custody, correct?
Yes.
Okay.
In fact, we saw an interview with him in custody, in stripes.
Same with Carmen Lauber, right?
Mm-hmm. Yes.
Yeah. Okay.
And once again, this instruction is designed for the situation where the snitch doesn't know anything about the facts of the case, wasn't a witness to anything. They just happened to be a cellie or something like that. And that's what this was designed for. That is not this case. Both of them were witnesses to the things they observed. There was discussion about immunity, and for that reason, we object to this snitch instruction. And if we have to have something, then maybe either add to the witness veracity instruction or something along the lines of Garcia mentioned before.
All right. Let me think about this for a moment. Mr. Burmester, putting this instruction aside for a moment, any objection to including the 10th Circuit form instruction from Garcia?
I think the 10th Circuit instruction from Garcia is fine, but I think it's duplicative if you're talking about the snitch instruction as well.
I understand. And Ms. Nestor, I understand defendant's position to be the state should give both instructions properly edited.
Right. It is occurring to me, if the concern is there is a federal instruction that we often use when we have what are called unindicted co-conspirators, that are people that were actually involved that then flip on whoever's didn't flip.
Provide helpful information.
Yes, sir.
Yeah.
I don't like that word snitch, but
Yeah.
That one may be closer to the facts of this case. I just than this one is, and I can pull that up really quickly. It's a 10th Circuit pattern instruction for unindicted co-conspirators.
I'll take a look at it during a break.
I'll submit it.
Yeah. Okay. We'll come back to that. We have
Okay.
time. Okay. I've made some notes. We'll return to this issue at some point. Okay. Pages 26, 27, 28. Standard Muji second closing instructions. Any objection, Mr. Burmester?
No, Your Honor.
I'm sorry. Which pages, Your Honor?
26, 27, and 28.
I think you have the fact versus expert witness in here twice. I think you have it on page 32 as well.
That's entirely possible.
So I don't have an objection to it. I just think we need to only have it on once.
Yep. I will take it out of this position. I'll omit page 26, keep page 32.
Okay. All right. And then the presumption of innocence is fine. The reasonable doubt, I understand this is a Muji. I understand there's some litigation going on as we speak in other states and in this state. It has been at least touched on that the language that that reasonable doubt is evidence which leaves you firmly convinced that the defendant is guilty of the crime charged. There is some real question if firmly convinced actually properly describes what reasonable doubt should be. I understand this particular instruction has been accepted by the Supreme Court, I think in case law and obviously in Muji. So I concede that but I would like to preserve that error because I'm not sure that's going to remain this way forever. And so we object to the language of firmly convinced as being not strong enough to describe what beyond a reasonable doubt is.
Okay. I understand, and the record reflects that the defendant is objecting to the definition of beyond reasonable doubt as evidence that leaves the jury firmly convinced that the defendant is guilty of the crime charged. The court notes that defendant's objection in argument is based on State versus Wall, 566 P. 3rd, 833, paragraphs 51 through 55. On balance and based upon the current weight of Utah appellate court authority, defendant's objection is respectfully overruled. Anything further on that, Mr. Burmester?
No, Your Honor.
Okay.
And then what was the last one you went through, Your Honor?
Well, then we go to page 29,
right,
which is not a Muji standard instruction, but is a copy and paste from the last paragraph of burden of proof from the opening instructions.
Yes.
I see no harm in giving it again. This is what you asked for, right,
yes.
Ms. Nestor?
Yes, thank you for doing that.
Mr. Burmester, any objection?
No.
Okay. Bear with me, folks. Let me just make sure my notes reflect what we've talked about so far. Okay. That brings us to page 30, Muji
No objection.
standard instruction.
No objection.
Mr. Burmester?
No objection.
Okay. Page 31 is the court's effort at a 404B instruction. It uses the structure of the Muji second 404B instruction inserts the case-specific language requested by defendant. Mr. Burmester.
Your Honor, if the court is inclined to give this instruction, we would ask that it include all of the 404B non-character purposes, not just motive. But
do you have any other non-character purposes for that evidence?
Yes, Your Honor. Like all but one or two of them, I think, can apply.
Well, but as I understood, the only reason, and when I instructed the jury in real time, the reason I gave them was motive. Was you weren't? Was it also go to
can
preparation?
It go to identity, preparation, intent?
I know it can, but we tried the case. Is that why you admitted it?
Your Honor, I should probably speak to that one. The answer is yes, and it's been throughout our briefing since, the entire motions in limine practice. We, argued for the admission based on motive, intent, plan, and preparation, and identity. Those words are always lumped together in our briefing.
I know, and talismanically, but not necessarily with factual basis. And so help me out. If I'm going to tell them that they can consider them for those specifics, there's got to be a basis. Or we can say other purposes such as motive. The reason I'm coming back to this is I want to be as close to the instruction I gave them as real time as possible, which we litigated in real time. And I didn't say the talismanic words in real time. I said motive.
Yes, Your Honor, but I think the court said motive based on what the defense was requesting in the instruction. The state wasn't limiting the instruction at all.
May we say such as rather than all of those combined?
I'm sorry, could you just say it in a sentence?
Yeah, such as determining motive, preparation, plan, or identity.
What is this, a spelling bee? Can you use it in a sentence, please?
Or determining things such as motive, plan, preparation, or identity.
The limited purpose of determining things such as the defendant's motive, plan. Okay.
Yeah.
Yes, sir.
Okay. Ms. Nesser.
Well, I think the court was right initially. I've never been under the impression identity was an issue in this case. I don't understand how any of these things would go to plan or preparation. I think the way it's written is correct, so I would object.
Certainly the first bullet point would go to preparation or plan. Plan, not so much preparation.
I just would like the record to reflect we object to it, Your Honor.
Okay, hold on a second. I'll just make a note of this. We'll come back to it.
Is that Katie or Amy? They look alike to me. That would be Eric's sister. Was that Amy? Surprised we didn't get to hear from her during the case.
Okay. 32, 33, 34, 35, 32 through 36 are Muji second standard instructions.
No objection from the state.
Your Honor, on 33, the law enforcement officers, I think that should be plural. Many law enforcement officers testified. So I think we have it in the singular right now.
Okay. You heard the testimony of law enforcement officers?
Yes.
Got it.
And then the rest I don't have any objection to.
Got it. Will do.
Lady Draconis, I'm not sure yet. We're trying to figure out how this one's
37 versus page 38. 37 is the motive instruction that the parties proposed pre-trial. It talks about Kouri Richins' motives, plural, which little fuzzy regarding the law. Here, there are two aggravating circumstances. One qualifies as a motive, the other qualifies as means. The motive would be an element to the extent it's the aggravating circumstance. The means is an element to the extent it's the aggravating circumstance. In the abstract, if the jury were to find unanimously regarding the means, but were not able to reach unanimous agreement regarding the motive, there'd still be a basis for a conviction. So the the court proposed the version on page 38.
Can I clarify? I was with you up until the very end of what you said, but I think the court's probably right. Are you saying that the only thing that requires the motive is the subsection 1 of the aggravated murder, which is committing homicide for pecuniary gain?
Well, so if we go to the elements instruction, we just want to look at that together as an example. So go to page 41.
Right.
You could have 8 jurors that unanimously agree on elements 1, 2, 3, and then when it gets to 4, they're going to have to unanimously agree regarding one of the 2 at least.
Correct.
Now, they could unanimously agree regarding 4B without ever agreeing regarding 4A and without ever agreeing about a motive at all, just regarding the act.
I think that's right.
And so the way the parties had written it beforehand did not contemplate that possibility.
I think you're right.
I'm just not convinced that motive is coextensive with intent. And I think the state is required to prove it was the intent of the defendant to cause the death for the purpose of...
Yeah, the difficulty here is the pecuniary gain is a why, not a how, and why is motive.
Right, that's right.
Well, motive might be my financial situation is so distraught, I'm going to commit this murder. Or I'm just so darn greedy, I just want more money, so I commit a murder. I think motive might be involved in both, but I have to prove that was the intent to do it, was to make the money, whether you had the motive, this underlying thing or not. I don't know.
I believe intent goes to intent to cause death.
That is among the things that the jury would have to find unanimously.
Right. The pecuniary gain is clearly motive. That is a motive that they've alleged. And I agree that I think subsection B does not require a motive because it doesn't matter why she's administering the lethal dose, just that she is administering the lethal dose. And I think we just missed that in the one we submitted. I think the court's right that motive only applies to 4A, and so it's tricky to explain this to a jury without a side-by-side analysis of the elements instruction.
Now, another option, right, is just to not give a motive instruction.
That would probably be the best. Except that...
Because then we don't have to get confused about whether the why is part of 4A versus 4B. We can just not instruct regarding motive.
I mean, I do believe the motive is there in the elements instruction, whether we explain whether it's a motive or don't explain whether it's a motive, they still have to prove this. So I'm okay with no motive instruction.
If we take the motive instruction out, it kind of frees everybody up to talk about what they really mean.
Right.
Without having to thread the needle of what's an element and what's not.
Let's do that, Your Honor.
Yes.
Okay. Any objection, Ms. Nestor, to omitting a motive instruction entirely? A separate motive instruction?
I think it's just utterly confusing. It's going to confuse the jury. I think we should take it out.
Understood. Pages 38 and 37 are omitted. Okay. Page 39 includes definitions. In fairness, I'm not sure I got them all, so we may have to add some more in here as we go.
Your Honor, I think we've removed the domestic violence recitation, so the cohabitant indirect definition isn't needed anymore.
Yeah, it was unclear to me. It was a sentence that I read regarding counts 1 and 2 as part of the reading of the information, but we can take it out and just proceed as if it doesn't matter. What's the state's position?
Your Honor, I know we didn't pull it as, I guess we pulled it by agreement as an element of the offense, not as a sentencing enhancement.
Right.
So I think the status quo is the parties agree that if the defendant is convicted of counts 1 and 2, that there is the DV sentencing enhancement automatically.
Right. That's right. It goes to sentencing, not to conviction.
But don't we need the jury to specially find it beyond a reasonable doubt in order for me to rely upon it at sentencing?
Yeah, I think that was part of the stipulation, is that it is just a stipulation of finding.
You're stipulating to a jury finding?
The court's going to be able to find that, Your Honor. They were cohabitants.
Well, I just need a waiver of Ms. Richins' right to jury determination on that, and then I can make the finding afterwards if that's how you want to proceed, or you can just stipulate to the fact now. I genuinely don't remember what we did with this prior to opening statement.
We do not want the issue of domestic violence in any way to be considered by this jury because it has not been addressed. It's too confusing.
Okay.
And in return for that, we agreed we would not challenge that they were cohabitants if the court has to be faced with determining whether or not there should be a sentencing enhancement for that.
Okay.
At sentencing.
May I put it in my language to see if you're comfortable with it?
Yes, sir.
Ms. Richins has the right to have a jury determine whether she and Eric Richins were cohabitants beyond a reasonable doubt. Is she waiving that right and submitting that issue to the court for determination by the bench?
She is.
Okay. Ms. Richins, do you understand the rights you're giving up?
Yes.
Okay. Are you waiving those rights knowingly and voluntarily?
Yes.
Okay. I accept your waiver. Find it's knowing and voluntary. On that basis, I'll remove any reference to cohabitant throughout the instructions. Agreed, Mr. Bloodworth?
Yes.
Or Mr. Mercer, sorry. Ms. Nestor, any objection?
No, Your Honor.
Okay.
Okay, is this, Fred, Mr. Burmester, is this definition of attempt the same as yours?
Yeah,
Hey, Fred.
That was added by the court before I ever
Before you
got a
did this.
chance to ask him to include it. It appears to be the same thing. So.
Okay. Just one moment, Your Honor. Can I just compare something just very quickly on the attempt?
We'll we'll need to take a break, so put a pin in it if you want.
It just will take me 1 second.
While they're doing that, a good rule of thumb is that each page of jury instructions takes about 1 to 2 minutes to read. Not every page is a full page.
Okay. All right,
so when we say
we can
39
just toss
pages,
this, right, Mr. Burmester?
it could be about an hour of jury instructions.
All right. No objection to the rest of the definitions instruction, Your Honor.
Okay.
Or to number 40, which comes after it.
Thank you. Mr. Bremer, is there any objection to page 40?
No.
All right. That brings us to pages 41 to 42. Elements of criminal homicide, aggravated murder, count 1. It is the italicized language that represents a addition or proposal by one party or the court.
So the italicized language included under number 4, the concern that I have in this case, and there may be a better way to deal with it than this, but I wanted to just bring it all out for discussion, and I'm not really married to how we address it. I think you know where I'm going with this. So there is testimony that has come in, or evidence, either testimony or documentary, that could let a jury find that Ms. Richins purchased oxycodone thinking it was oxycodone, and it was actually a fake oxycodone that neither she nor Mr. Richins were aware had fentanyl in it. My concern is if the jury thinks that under that circumstance, it would be aggravated murder, which it would not. It would be a different offense, which is not charged here. It could be a lesser included offense. So I don't know how to carve out. It's my reading of this statute and the information that in order to convict Kouri Richins of aggravated murder, which is this count, they have to believe that she knowingly and intentionally caused his death. If a jury is confused about whether knowingly and intentionally causing someone's death means buying something you think is oxy, giving it to someone and it's actually fentanyl and they die, that's a problem.
Well, pause for a minute. Let me ask you some legal questions.
Right.
So I acknowledge that you tell me.
Okay.
I'm learning about this in researching these instructions and seeing your proposed language.
Right.
Assisted suicide manslaughter is a crime with specific elements in the state of Utah, right?
Right.
Under 76-5205.
Right.
If, for example, a defendant in a murder case wanted to request a lesser included offense based on this factual theory, they would have a basis to do so because that lesser included exists.
Correct.
That's not the same as saying, though, that the state has to disprove that alternative beyond a reasonable doubt. It's not an affirmative defense.
Right. I agree with that.
So I don't think I have to include that language in the elements. The real question is whether you're asking for a lesser included, or I mean, you could certainly argue to the jury some factual inference that, listen, there's an inference to be drawn here that she got this stuff for him because he wanted it.
Yeah.
That line of reasoning or doubt.
So.
But I don't think the state has to affirmatively prove without a reasonable doubt that this isn't assisted suicide manslaughter.
So I think that the state has to prove it was a surreptitious administration. And I don't know how. I don't think it's enough if she administered it by handing it to him and he said thanks and ate it and died. So I don't know how we address that with the jury.
Does that follow from the elements in the statute?
It says by the administration of any substance, and it doesn't say. I just don't think that's aggravated murder. If she administers it by handing it to him and he says thanks and eats it, that's not aggravated murder.
Well, here, I'm going to create a very morbid and dark hypothetical.
This is all morbid and dark. So.
Imagine a healthcare provider says to a patient, would you like some morphine to help with your pain? They say yes, and then pushes the plunger way too far intentionally. I think that's still aggravated.
That's an intent to cause
to
death,
cause
though.
the death. Yep.
Right. But we've got witnesses of the state coming out talking about you can be fooled by these pills. I mean, they've put that testimony
Yeah,
on,
but that's
right?
a different element, right? You're down on 4B. I mean, I'm down on 4B. Intent to cause is up on elements 1, 2, and 3. We're talking about the how, not the intent. The intent as to the result is the top level. That's homicide. It's the aggravating circumstance that's 4B. let me pause there. I'm carrying a lot of water here. Does the state see it the same way?
Yes.
Okay.
Yeah.
And Your Honor, this, from reading the tea leaves on how the facts came into evidence in this argument, the state is concerned that the state is concerned that the defense will not be precise in arguing the intent in closing, right? The evidence has come in, and this discussion here today has suggested that the defense is putting the intent on a specific drug to kill, and that's not where the intent lies here.
No, but would you acknowledge that if the defense were able to persuade the jury, for example, that Kouri Richins intended to give her husband a non-lethal dose of hydrocodone, that would be a permissible basis to argue that she is not guilty of aggravated murder?
That is a permissible basis to argue she's not guilty under the second element of aggravated murder.
Why not the first, second, and third? She didn't intend to cause his death. She intended to give him non-lethal painkillers.
Well, okay, second and third together.
Yeah.
You know, we split them up here sometimes. They're in the same sentence. It's really weird that we split them up.
Right.
But the second and third together,
Right.
Sure, that is fine. But intent is not an element of 4B. Like
Agreed. Oh, I agree.
I actually agree with that too. I was just trying to figure out how to deal with this scenario and not have a jury. I guess we'll just focus on intent in the argument.
Yeah, it's intent to cause a death. Intent to cause a result, that's where the intent lies. If you intend to cause the result by means of administering what you think is fentanyl and it turns out to be hydrocodone and it's deadly either way, doesn't matter. Or vice versa.
Right.
Yeah.
If you intended for the end result to be to die.
Right.
I agree with that.
I think we're all agreeing.
I agree with that.
Okay. Can we put 2 and 3 into one sentence?
We can. We typically don't, Utah, because we want to make sure they separately, unanimously find beyond a reasonable doubt the culpable mental state.
I also think there needs to be a separate finding of causation. I think they should be apart.
So, I mean, this is the way the elements instructions under Mucci typically work.
Yeah.
It's confusing.
You can send a strongly worded letter to the Mucci committee, but I'm going to stick with this for now.
Yeah.
But we're going to strike. Let's just go down the page here. Mr. Burmester, did I cut you off there?
No, Your Honor.
Okay. We're going to strike the language without the knowledge or consent of Eric Richins because the court rules as a matter of law that language does not represent an element of the crime or an affirmative defense that the state has to disprove beyond a reasonable doubt. Okay. Then we get to the extra italicized language, of which I've provided two versions, one more elegant than the other, and the more elegant one isn't mine. But rather than have a separate instruction for jury unanimity, one offense in 2 ways, I thought we'd just include the operative language here. And all we need to do is expressly instruct the jury that there are multiple ways to find that this was committed beyond a reasonable doubt, but you've got to agree about which one of the 2 aggravating circumstances you believe the state has proven.
That's 100% the law. That is correct.
Yes.
That's not always the case in other states.
You're right, because I was going to say I thought we did this, but you're right. We put it in a separate instruction. This is much better to put it in the element instruction, I think. I like it better.
Let's be clear. This was Melanie's idea.
Yay, Melanie. Yeah.
So we're talking about the top.
So you've got
One with A and B,
you got
right?
two options here, right? You got the more wordy option before the or the more elegant version after the or.
This is so fascinating.
I think the top one's clearer. Even though it's longer, it's clearer.
Oh, you're right. I'm sorry. We'll put reason instead of motive in there. Good catch.
Man.
So, Ms. Nestor, if we were to see in the top version, instead of saying for the motive of pecuniary gain, may we say for the reason?
Yes.
Okay.
And I think you also have motive
In the very beginning.
in the first sentence.
Yep. The reason or means. You know, as we do this, though, I'm kind of leaning towards the second version.
Your Honor, the state does too. I also think we need to account in the second version for the possibility of finding both. I mean, you say at least one,
Right.
but there, I think in the next line, and you must unanimously agree which circumstance, I think we parenthetically plural it.
You want to say which or both?
Yeah, something like
Okay.
that. The state has proven.
Yeah, we can do that. Do you want to say which circumstance or circumstances the state has proven?
Yes.
Or just put a S in a parentheses, like, so it could be either.
What's that? Yeah. We'll just say
Red
which circumstance or circumstances. We're going to go with option 2, Ms. Nestor, notwithstanding
Okay.
the time I wasted on option 1.
Okay, end of the year, I want this guy to get the most humble judge award.
Okay, pause there for a minute. With, I'm just going to read it out loud. You tell me if it hits the ear correctly.
Okay.
To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt, and you must unanimously agree which circumstance or circumstances the state has proven. If you find the defendant guilty of aggravated murder, you must determine, we'll get rid of that sentence. Got it, thank you. And we'll just we'll mark your decisions on the verdict form. Okay. Ms. Nestor, anything else there?
That'll be harder.
Just a
Harder to
moment.
prove.
I'm getting a text. I just want to make sure I'm listening to my co-counsel here.
Other cases, they've said you don't have to agree on the reason. You don't have to agree on what got her here.
Okay, no, that's fine, Your Honor.
But
Okay.
here he says you have to. You have to
I will make
unanimously agree.
similar changes to the elements of count 2. So we'll get rid of the italicized language in element 4. We'll strike the inelegant option 1, and we'll get rid of the reference to cohabitant. And then we'll add the or circumstances.
Okay.
Okay. With respect to the definitions of mental state, murder is homicide is one of the rare crimes where it is a result-based crime, not a intent or action-based crime, right? Notwithstanding your best efforts, if you don't kill someone, you did not commit homicide. So the mental state definitions have to be specific to counts 1 and 2, and they are different, I think, than counts 3, 4, and 5. Is that the state's view of it?
It's certainly with regards to 1 and 2. One would think this is a super easy thing to figure out if something is specific or general intent crime.
Yeah.
And I've struggled with it for 30 years. Maybe that indicates I'm stupid. But I have no objection to proceeding with the way the court is laid out.
Okay.
Right, 'cause
The mental state's definition on page 46.
Right. I think initially the ones we submitted, Mr. Burmester had actually put it on the bottom of the counts, and it was, I like this better, separate.
to see what they're
I
looking
don't know. I
at.
always question whether jurors ever understand this, but I think this is the best shot we have at getting it to them.
Yeah, in fairness, I should probably move mental state defined counts 3, 4, and 5 to after
You
the
give the elements instructions. I think that would be better.
But while we're there, Mr. Burmester, I understand you to say no objection to pages 45 or 46. Is that correct?
Correct.
Okay. Ms. Nestor.
So you're going to move what's on page 46 behind the elements instructions for 3, 4, and 5.
Correct.
That's better, I think.
Okay. Any other objection?
Just 1 second, Your Honor. I think this is the same language we had.
Red, do you just really want to be in here with your red pen?
Yeah, no other objections to that.
Okay. All right. I have lots of questions regarding elements of 3, 4, and 5.
Yeah, so do I.
So I got to pull the information. We got to look at the statute. Bear with me for 1 moment.
I'm such a visual learner. It is so hard for me to follow what they are talking about. It would be so much easier if I could see what they were looking at.
Melanie, I'm not ignoring you.
I was, Melanie. I was ignoring you.
All right, so let's focus on count 3 for a moment. It's insurance fraud, allegedly committed somewhere between January 29 and August 31. It is charged under Utah Code 76, 6, 521.
D.
2D, right?
Mm-hmm. Yes.
All right, so let's start with a couple of my mental state. Because the statute does not specify a mental state, it's intentionally, knowingly, or recklessly, correct?
Well, it says it specifically in Part D.
Oh, with the intent to deceive or
It's
defraud.
a specific intent.
Oh, there we go. So this is where it gets confusing, because 2 says with intent to deceive or defraud, and then 2D says intentionally, knowingly, or recklessly devises a scheme. So different intents for different parts of the elements, right?
Yeah, okay.
Okay.
Yes.
Devises a scheme or artifice to obtain ... anything of value by means of false or fraudulent pretenses, representations. So, 2 questions here. I don't see from an insurer anywhere in the statute.
Agreed.
May we strike that language?
Yes, from the state.
I mean, I don't want to add language in, so
Okay.
that's fine.
So we'll take that out. And then, Ms. Nestor, in your submission this morning, you make reference to 2D's phrase, fees for professional services.
Right. So I read this statute differently than the state does. I think they're trying to shoehorn a crime that is a different crime under the statute. I think if you read the plain language of the statute, taking out fees changes the whole nature of what this crime is. I think this is actually not the proper crime that they meant to charge, but now that they've charged it, I think they have to do it as written.
Well, tell me why subsection 521(2)D doesn't read as follows based upon its plain language.
Hold on, Your Honor, can you give me 1 second? I had to pull the statute up on my screen.
No problem.
Just let me catch up just a minute.
Must be Utahns. It sounded normal to me.
Excuse me.
Oh, that's a special kind of kinesthetic learner. It's I can't remember what it's called, but it's just writing notes.
All right, just a
in the
minute,
same way.
Your Honor. 76-6 Okay, I'm with you. Please continue.
All right, so 521(2), an actor commits a fraudulent insurance act if the actor with intent to deceive or defraud does one of a number of things, but as relevant to this case, D, intentionally, knowingly, or recklessly devises or scheme or artifice to obtain two categories of things in the alternative: fees for professional services or anything of value, and then by certain means. Why doesn't it apply equally to two alternative categories of things?
I read that differently.
Okay.
And this is the fun part about, plain language, right? So I read it to say that this is the crime for when someone is pretending to be to get fees for selling insurance fraudulently. That's what I think this section of the statute is. And I think the fees part applies to, it should be read to obtain fees for professional services or anything of value. In other words, I'm trying to get someone to pay me as an insurance broker by making false representations about what I'm selling you. I'm selling you something that's junk. It's not what you think I'm selling you. So I'm either trying to get a fee or have you pay me for the actual product that I'm selling you, but by means of lying to you about what it is I'm doing for you. That is what I think this is. And that is not anything to do with Ms. Richins. I think they liked that second half of that and pretended like the first half didn't exist. And that's how I read this crime, because that is a crime. There are people that I've represented them. They go around and they sell junk. They sell a policy that doesn't cover anything, and they get either a fee from you as a broker, or they get a commission, which from selling you, they get a commission of the junk product, and it's fraud. And that's what I think they're talking about in this crime. And I don't think it applies here. And I want the word fees in there because I think they picked the crime. They got to prove it as it's written. And they just deleted that word.
Well, they're not proceeding under that theory, but it's in the alternative. I have to acknowledge the comma and then the word or.
Mm-hmm.
And I can't consider the word insurance in the title of the section. That's non-substantive. In fairness, I see that the word insurance appears in section 2, so I understand. I'm looking at the definitions, though, for the part and the definitions in 101.5, and they don't define insurance. And the legislature's got to call it something. They chose to call it this. This seems analogous to the statute for communications fraud, which really is fraud. Like the communications in the communications fraud isn't doing much besides requiring that somebody communicate something by speech, writing, whatever. I too wrinkle my brow at the inclusion of the word insurance, but it seems just to be a label that the legislature has used. The substance of the statute on its face says what it says. Are you aware of any reported decision limiting the scope of this statute?
I tried. I looked. I couldn't find this particular, because I just kept reading it over and over, and I'm like, this is what you charge brokers with. This is what you charge, scammers in the insurance industry with. That's this crime. And I object to taking any words out of it exactly as it's written, because I don't think they've proved this, and I actually think they charged the wrong crime. I don't think that applies to the next two, but I do think it applies to this one.
You'd acknowledge that even if we put it in, it'd be an or.
Well, depends how you read it. I mean, if you take out the words or anything of value, Or
No,
it doesn't
I
make
wouldn't
sense.
take those out.
No.
Yeah.
I'm saying for purposes of trying to understand it in context, right? So like the initial part of this says intentionally, knowingly, or recklessly devises a scheme or artifice to obtain fees for professional services, comma, or anything of value. And their reading of that is that or anything of value goes back to a scheme or artifice to obtain. But I don't think that's right. I think it goes to either for professional services as their broker or anything of value, like you made them buy a product from you. And so I think they should have to say exactly what it says on here, and the jury's going to just have to figure it out. But
Okay, but even in your world, in your view,
yes.
I hear you saying it would be 1, Kouri Richins, 2, with intent to deceive or defraud, 3, intentionally, knowingly, or recklessly devised a scheme or artifice to obtain
Fees for professional services.
3A, fees for professional services, comma, or 3B, anything of value.
That's not how it's written, though, Your Honor.
It's exactly how it's written.
No,
I just put the comma and the or in the same place.
No, you put a B in there, an A and a B, and I think it's all connected. I don't think it's written that way.
Okay.
Or is AB.
Well, then we should take the 1, 2, and 3 out as well.
Take the which one?
Never mind. I understand your point.
Yes.
Okay. Mr. Burmester, go ahead, sir.
If we're going to add the theory that we're not proceeding under, then it should be A and B to make it clear, because it is an alternative. It's a list of 2.
Yeah. I don't know how to read it any other way.
If that's wrong, it comes back though, because that's not. These go straight to elements.
Okay. So, Mr. Burmester, any objection to including the language in the alternative form as it exists in the statute?
As long as it's A, alternatively A or B.
Okay.
I object to the A or B, Your Honor. I think it should be all one sentence, like exactly like it's written.
I understand your position. Okay. Let me give that some thought.
You're just wrong, he says. That or comma, that sounds like A or B.
Your Honor.
Mr. Ramos, go ahead.
Just as you're giving it some thought, and I'm looking at 76.6.521 from the code.
It's the water cooler.
An actor commits a fraudulent insurance act. I had missed it on, Your Honor probably didn't miss it. I missed it on the first one, but going back to the insurance act, that isn't in the instructions as it currently is, but just highlight it now as Your Honor looks at that.
Okay. Thank you, sir.
Thank you.
Only funsies, thank you for your massive support.
I've got a note there. We'll keep going. Regarding count 4, I didn't see any disagreement between the parties regarding the elements for count 4.
No disagreement, Your Honor.
Mr. Burmester?
Did we talk about element 4 of count 3? Because I'm not sure where that came from.
Oh, thank you. Yeah, you're right. I went too fast. I don't understand where that came from either.
I'm sorry, what? I didn't understand what he said.
Paragraph 4 of the elements on count 3
on
page
count 3.
47.
I'm sorry, I got to go back. Just 1 minute. I thought we were on 4. Okay, element. Oh, took a substantial step. That came from case law. That's case law.
Have the citation?
I did on the one that I filed. Let me pull that up, Your Honor.
I think the record is 255. 255. It was nuts. Wild day.
It's document 1584 on the docket. And
by multiple people. I think on that day, Nurse for God had gifted 100.
Wait a minute. Count 3. This is a different one. Let me see, I might have written it in my notes to the state. Just a moment, Your Honor.
Check the orange notebook. It might be written in there. I thought it was funny when the camera panned over to see Mr. Ramos, but he's on WebEx, so we just saw the water cooler. That was funny. Ramos and Lewis are on Zoom or WebEx. They're with us in spirit.
Oh no, I don't think that came from me. I don't think that came from me.
Nobody knows where it came from.
It did not come from the state.
The judge didn't put it there.
Did. I can go back to what you emailed, or from the parties, and was represented as, but it's not in the statute. Neither is the definition of insurer, and neither is the definition of substantial step. That's why we have highlighted
Oh,
those.
I know where this came from. Mr. Bloodworth and I had a discussion about the fact that the way that it was originally written, she wouldn't have had to do anything. She could have just imagined it and never taken an actual step towards the commission of the crime. And that language got put back in after we had that conversation. I think, and we were trying to fix that problem. And I think that was what Mr. Bloodworth added to fix the problem. I was the one that originally said the way it's written, she could just think about it and be guilty. She wouldn't have to do anything.
I think an act is kind of implicit in 3 by means of false or fraudulent pretenses, representation, promise, or material omission. I think that's the act here.
Well, I understand the point. It seems that the actus reus under 521(2)D would be the devising the scheme, which I think is Ms. Nestor's point.
Right.
Well, if you devise it,
I could think of one right
and never
now.
say anything,
Right.
or do anything, have you violated the statute?
Right.
So what is the actus reus? What's the conduct?
By means of, and then those.
Well, but that's just a modifier on the scheme
Right.
that you've devised. I think the operative verb there is devising.
I do know in federal court law, it's clear you have to take a substantial step. I don't know if they just have an objection to the word substantial, but you got to do something. Something has to be done other than thinking of it in your head.
Why don't we just instruct regarding what the state's theory of the crime is?
Right.
And either they proved it or they didn't beyond a reasonable doubt.
That would be fine with me.
Judge with a revolutionary idea.
Count 3 is I get confused between count 3
It's
and
the
4.
scheme one with the $100,000 two-stage policy.
Yeah.
Filing of the application.
Oh, my funsies.
Yeah, the fraudulent, false or fraudulent pretense.
It's the submission of the application with the fraudulent stuff on it, right?
It's the submission of the application, but it could also be
Just signing
filing
it.
the claim as well, but yeah.
Okay, sure.
Thank you so much. Only funsies.
You could, yeah. You could.
You are most
We
generous.
could instruct the jury that the state's theory is that Kouri Richins committed this crime by A, B, and C. I give it.
Or-
Yeah, right. Yeah. We'll take a break. You can all give that some thought. Maybe talk to each other. I understand your concern. But it seems that we don't need to be coy. We can just tell the jury what the state thinks, and either the state proves it or they didn't.
Yep.
Okay, give that some thought. Okay. In terms of our initial review, let's keep going. Elements of count 4. Just read through that for me for a moment. Let me know if anything sticks out.
Prosecution and defense are hashing out with
This
the
I
judge.
don't have an objection to, Your Honor.
the
I think this
instructions for
tracks
the
the
jury.
statute and it also tracks the case.
Okay. Mr. Burmester, let me know when you've reviewed it.
On 4?
Yes, sir.
No objection. Sorry.
That's okay. So then let's look at elements of forgery, count 5, 76-6-501. 2B1. An actor commits forgery if, with purpose to defraud anyone, or with the knowledge that the actor is facilitating a fraud to be perpetrated by anyone, the actor makes, completes, executes, authenticates, issues, transfers, publishes, or utters any writing, so that the writing or the making, completion, execution, authentication, issuance, transference, publication, or utterance purports to be the act of another person, whether the person is existent or non-existent.
Whoa.
This is the signing of the true stage life insurance application, signing of Eric Richins' name, allegedly, to the true stage life insurance application. Correct, Mr. Burmester?
Yes.
I didn't know you could utter a forgery.
Oh, there it is. You got it.
So we've got to keep with purpose to defraud anyone in there, right?
Yes.
Out of paragraph 2.
Yes.
7/10.
Okay. But then, I think, if I understand what you submitted correctly, you're asking for without the authority to do so.
Right. That's right. And that's based, I decided the case law on that. State versus Gonzalez, state versus Collins, and I think the state has agreed to that.
Is that correct, Mr. Burmester?
Yes, Your Honor. That's an element that
Very good. So
supported by those cases.
2 and 3 stay in, correct?
Yes, sir.
Yes.
And then do we need to, can we skinny down 4 in any way to match the state's theory? Or
I don't know.
it's
if
just
we
the way
have
it goes?
Authentication.
I mean, execute and authenticate don't really match the facts of the case.
Isn't execute just sign?
Yeah, because I thought execute meant make it effective. Like, I don't know. And authenticate usually means notarize or something like that. I still don't know what utter means.
Well, we can go back to page, any intentional act that puts a writing into circulation and implies by word or action that the writing is genuine.
I mean, it just seems like you could say make or complete a writing, or just make a writing.
Make or utter.
Yes.
Make
That's
or
what I
utter.
think.
Utter's a weird word. Makes me think of a cow.
Mr. Burmester, make or utter, or make, execute, or utter?
Either of those two alternatives are fine for the state.
All right. Court rules that paragraph 4 should read, did make, comma, execute, comma, or utter a writing so that the writing or the making, execution, or utterance purports to be the act of another person, whether that person is existent or non-existent. Do you want to take out the last clause?
I mean, we're dealing with an existent person, so
At the
it
time,
seems
yeah.
kind of pointless.
Any objection, Mr. Burmester?
No, Your Honor.
Okay. Got it. Thank you. Okay, pages 50, 51, 52, 53 are Muji second standard instructions.
Yeah, I agree with that it is 50. But,
Thank you, Staff Life. Thank you so much. Have gifted memberships.
it certainly doesn't preclude one from arguing where two charges might be related factually.
No, certainly not. The state in its closing can start with count 1 and then pivot to saying you can consider the strength of the evidence regarding count 1 as part of your consideration of count 2.
Okay, I just wanted to make sure we're
What
not.
we can't let the jury think is that if they find a defendant guilty of aggravated murder, well, screw it. We're just going to click guilty on the rest.
I totally understand the rationale for it, but
Okay.
as I read through it, I was
Yeah.
kind of concerned.
Okay. Page 54 is a edited version of what would normally come after as the second paragraph of page 53 to reflect that this verdict form has a lot more blanks than just 2.
Okay.
I'll take a look. You will see, please, the verdict form is separated into, I'm just going to say several sections.
To several sections?
Yeah.
Okay.
One section for each count charged. Any objection, Mr. Burmester?
I couldn't understand what you said.
No problem. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into, it currently says 2. I'll edit it to say several sections.
Okay, no objection.
Ms. Nestor?
No objection.
Okay. 55 is a Muji standard instruction. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
56 is a Muji standard instruction. It was part of the party's proposed inclusions pre-trial. I'd like to hold it in reserve so I at least have a place to start if the jury reports that they're having trouble reaching consensus.
Well, I just don't see the harm in doing, I mean, I think I always want jurors to be instructed by the court, not just us, that they're not to surrender their honest conviction as to the weight or effect of the evidence solely because of the opinion of their fellow jurors or just to return a verdict.
I agree, and that's why you should look at paragraph 3 on page 51.
Oh, okay. Did you stick it in there? I didn't see it.
No,
Sorry.
it's just part of the standard overarching unanimity instruction.
Oh, that's fine.
Recently had a hung jury. I need a place to start to apply gentle pressure to keep working, and this is something I'd like to have in reserve. Okay, so I'm not going to give this as part of the pre-closing instructions.
There is a typo on it.
I'll fix it. What is it?
Third line from the bottom, do not surrender.
Thank you. Got it.
That's kind of an important section.
Yep. Okay. All right. May we please, and Ms. Nestor, we're going to come back to your submission here before I take a break.
Okay.
But let's go to the verdict form next.
Okay.
Just
In
moving
fairness,
right along.
this was the last thing I did before I came on the bench, and so there may be some typos or flow errors here, but let's just go through it one at a time as if we were jurors answering it to make sure that it flows correctly.
You want the verdict to have a good flow to it.
Okay, give me just 1 second, Anna. I'm sorry.
Your Honor, I don't listen to the beginning. I don't think I got a copy of the verdict.
I think it was in the email that I sent after I sent a copy of the jury instructions.
I did not receive that email.
Hold on, Wendy, I'll send it to you right now.
That is entirely possible.
Thank you.
No, you did. Or at least I sent it.
I didn't get it, but
Let me forward
I can maybe
Okay.
just resend it.
Yeah, I'll send it right now.
Thank you.
You've got mail.
Okay. I just sent it.
I should say skip to count 2.
Oh, we're going to take out 1B. And so this has to change to right there. 2.
Do you remember when it was cool? Like that you've got mail. It's like, yay, I got an email.
2B.
When did that die? Probably about the same time spam became a thing, which was like day 2 of the internet.
Okay.
Only Funsies is on a quest to get rid of all gray people in chat. Everyone's going to be green. Thank you so much. What was the paperclip's name? Was it Clippy or something?
Okay.
That was the worst idea ever.
Oh, if we include it. Yeah. Okay. So let's see. Let's start with you, Ms. Nestor. So we'll take out the plural of inquiries and we'll say skip to count 2. There'll be no reference to 1B. We'll just omit inquiry 1B, right?
Right.
Same for count 2, similar changes?
Right.
Any other changes?
Yes, so I have some worries about it not being, I know we have an instruction on it that's separate, but I sure would like it to be clear on the form of the verdict about that it has to be unanimous as to each one.
Doesn't it say unanimously regarding each one?
It does, but
you want to stress it?
You could be saying you unanimously agree.
Oh, I'm sorry. Are you under 1A?
Yes, sir.
Okay.
So let's say they checked both.
So rather than say check all that apply, if I put in parens, check all regarding which you unanimously agree.
That would solve it.
Okay.
That would be that takes care of my concern. Because my worry would be they would mark them both and we would never know that they were unanimous on each.
Okay.
Or if they split it half and half. Does that make sense?
Yep.
Okay.
Any objection, Mr. Burmester?
No.
Mr. Ramos, my apologies. Go ahead.
No, I apologize, Judge. I jumped the gun a little. Just for flow's sake, right under guilty of aggravated murder, the in parentheses, I would suggest flipping those. So starting, if you mark not guilty, proceed directly to count 2, and then
sure.
After that.
That's fine.
Actually, that does make more sense.
No objection from the state.
Got it.
Same on.
Remains consistent with the.
And same under
earlier
count
question.
2 as well.
Got it. Okay. Then, before we take a break, Ms. Nestor, may I go through just what you've submitted this morning to make sure I covered it all, at least initially?
Yes, sir. Let me grab it just a moment. Okay, I'm ready.
All right, we handled the quote without the knowledge or consent of Eric Richins language on the record. Changing her to there, I didn't see a spot where that would be a problem in these instructions, but.
I think that only applied to the ones when Mr. Burmester had the definitions under the elements. I don't think it's a problem anymore.
All right. 3, insurance fraud. I understand your position, and I'll take a break and make a ruling on it.
Okay.
Same break. Break hasn't happened yet.
The forgery elements instruction, I think we've reached consensus regarding anything further there.
No, sir.
I've ruled on defendant's request for a different definition of what constitutes proof beyond a reasonable doubt. Any further record there?
No, sir.
Number 5. Why don't you have sufficient foundation pursuant to the witness credibility instruction on page 22 to make exactly this argument? I'm not sure this is a legal instruction so much as a strategically sound part of your closing argument.
I think the Portuondo v. Agard case opens the door for instructions like this. I do think there's nothing in the witness credibility that talks about this. And I believe in Portuondo it was used against the defendant, but I think this is an interesting issue. I mean, if you have a witness who has sat through trial and heard everybody's testimony before they take the stand, that gives them an edge. And I think a jury can consider that, and I don't think there's anything in our existing witness credibility instruction that addresses something like that. And I think we have a right to bring it to their attention and say, hey, if you want to consider that, you can, but you don't have to. And that's why we want that instruction. Because O'Driscoll was the last witness of the case. He had some very important testimony in this case, and he had the benefit of hearing 45 witnesses before himself and all the court's rulings on everything before and every out of the jury conference and everything. So I do think that's proper, and we are asking that it be given.
Mr. Burmester, I certainly understand why defendant wants the instruction. Anything further on whether they're entitled to it?
The state disagrees they're entitled to the instruction. Portuondo didn't involve an instruction. It was exactly that an argument was made by the prosecutor about the defendant being present, and the court said that's just fine. That can happen in this case, but it shouldn't be an instruction from the court. It shouldn't. There's no basis for the court to give its imprimatur on O'Driscoll's veracity.
And, and can I just, before you rule, Your Honor, I am fine if you want to just take some semblance of this language and insert it into the witness credibility so it doesn't seem to highlight, you know, as it being more important than any other thing they're supposed to consider when they're considering witness credibility. It's just one of a list. I'm fine with that too. So if that makes you feel more comfortable, I would do that as well.
I will, with the benefit of counsel's argument, take a fresh look at Portuondo versus Agard, and after the break, give you a ruling.
Thank you, Your Honor.
Okay. I understand defendant's position regarding United States versus Garcia. Anything further?
No, Your Honor.
Mr. Burmester.
I just want to reiterate that Garcia closer fits this than their point number 11.
Understood. We took out the defendant testifying instruction. That's handled.
Right.
We took out the children testifying and the age of witness instructions.
Right.
I've given the request for a re-emphasis of the burden of proof instruction. We have a 404B instruction. I need to just make a ruling regarding whether we'll be discussing motive as the other purpose or motive, plan, preparation, identity.
Right.
The other 404B purpose is listed in the rule. I'll come back on that. And then we've already discussed the in-custody informant instruction. I'll give you a ruling on that in a few moments. Anything further on that, Ms. Nestor?
No, Your Honor.
Ms. Nestor, anything further before you take a break?
The spoliation instruction.
You made reference to it in an email.
Yes.
Spoliation is a legal doctrine that has elements.
Yes.
You got to make a showing.
Yes.
You didn't
make a showing.
Okay.
Do you need a break, or do you want to just do it?
Let's
knock
take
it
a
out?
break while you get that lined up. Okay. But I, like some other rules, just saying the word doesn't necessarily get a party there. There has to be a showing. I have to make findings.
I understand.
So, all right, Mr. Burmester, anything before a break?
No, Your Honor.
Okay. 3:15, folks, please. Thank you.
3:15. That gives us a few minutes. Is this the first break? Did I miss any while I was out dealing with the contractor? The contractor insisted on showing me a video his company had made about how they repair concrete steps. I'm like, I've already watched. I went to your website. I've already watched the video. Yeah, but watch this. I want you to understand what you're getting. Like, I know what I'm getting. I looked it up before I called you. He had to stick to his whole pitch. First break. At 4:52. We'll be back at 5:15 Eastern. Can they replace a new roof with the wrong color shingles? Oh, I don't know. I'm hoping the roof looks good. I really am. Did they give you a quote? Yes. Do we have any concrete people in chat? Anybody that does concrete pouring, steps, sidewalks, that sort of stuff, walkways? My steps are 9 feet wide by 5 feet deep. And there's 1, 2, 3, 4 or 5 steps in that size. Cody right does. C&E can send me a quote. Call me C&E Masonry in Utah. The travel's going to be so much. He wants $3,200 to inject foam underneath and raise them up, which is a little steep.
Melissa Kyer.
Hello, Melissa. This is R.A. How are you doing?
Hey, you can take me off speaker. I'm sending you some more snacks.
Melissa, I'm sorry. You're on. I put you on with everybody, but thank you very much.
No, that's okay.
I appreciate that.
It's going to be here. Did you guys eat? I fell asleep when you guys were on last night. Did you eat the ghost pepper stuff?
Oh, yes.
I got to go back and watch that tonight.
I still have the original bag because these are hotter than I can handle. I can't just snack on these. I can eat like 3 or 4.
Well, that's why you lose weight, because you can only eat 3 or 4. You have to drink a bunch of water, and then you eat 3 or 4 more.
I cheated. I opened these and tried these the other day. I started them, and as soon as I tried them, I sent a picture down to Thomas, and he went out and he bought 4 bags of these. And he
oh my God!
them.
I started watching you when you started eating. I was watching you when you started eating those, and I thought, "Ooh, he needs a drink of water
or milk."
Go.
All our milk last week was like cottage cheese milk. I don't know what was wrong with it. We just got new milk today. It's all better. So now I can snack away and cool off as well.
Here's the thing about it was, you had them sitting at your desk for like 2 or 3 days before you would even try.
I was trying to build up the.
I know.
It takes.
You have to get up your nerve.
Yeah, these things are hot, like 20 times hotter than habanero. So
these aren't as hot. One is wasabi and soy, which I think you love.
Yes.
Yeah, and one of them is spicy dill pickle, and they're all nuts. And one of them is it's another kind of pepper, sunflower seed, but it's not near as hot as what I sent you before.
Nice. I enjoyed the spicy, the jalapeno roasted pumpkin seeds. I'd like to try the sunflower seeds. I like those. Of the two, I like sunflower seeds better than pumpkin, but those were both.
So do I, and I like pistachios better than all the rest.
Yeah. Well, thank you very much. Now I'm super excited. I will be watching the post office with the.
Okay, they're coming like 3 different days. They all come from different people because I ordered different brands. But it's like the 15th, the 16th, and the 18th, or something like that. So
awesome. Sounds good.
I just wanted to let you know to look out for them.
Sounds great. We might have some spicy stuff for Verdict Watch. So,
okay.
Thank you very much. Appreciate it. We'll see you.
You're welcome. Bye.
Bye. Thank you, Melissa, for the spicy food. Ivy says, concrete, try some retired mafia boss with a concrete mixer. Italians are always helpful. Yeah, but they want deep concrete that they can hide stuff in, and I don't need a deep pour. Let's see. Surprised they don't have a cow for the kids yet. We thought about getting chickens. I started building a chicken coop. The posts are they're cemented in the ground. I did that concrete myself. Actually, my friend helped me. He's passed away now, sadly. But I never put the chicken coop in. Didn't we watch a case where someone was buried under concrete? In the backyard, right? And then they sold the house. I think yes, but I can't remember. Anyway, I'm debating. I'm not the best at construction work, but how hard would it be to learn how to pour concrete steps? How hard is that? It's got to be pretty easy, right? You've got the form, you put the form in, you pour. Done, right? Is that it? It's not very hard. Why do they charge so much? Just because it's crappy work as far as like it's hard on your back and knees? I'll have to get one of those little trowel things to make it all smooth. Make them level. That's the problem. That's why we need new steps, because they currently slant. It's a ramp instead of a, yeah. No concrete in this trial, correct. Let's see. The finishing is the hardest. It's not easy. Concrete is expensive. Just the form is all you need. Okay, here's the next option. And I know this is taking the easy way out. But can't I just take the concrete steps out and replace it with wood? Isn't that cheaper and easier? Yeah, I need a jackhammer to break up the steps and haul it out. But could I just put wooden steps up to the wooden deck? Is that not an option? I'm not good at that either, but Red Pen, thank you very much for your help. Have a great weekend. Appreciate you. Wood is not cheap. Have we learned nothing in trials? Gotta lay foundation. What's the price of lumber? Oh, it's ridiculous. It's ridiculous. It cost me $120 just to trim around a door, to get wood, primed wood to trim around a door. I've got some left over, so I could do like 2 doors out of that, but still. Do you have to get a permit for building stairs where you are? No. The only thing you need a permit for is like plumbing work over $4,500 or something. It's some weird law in North Carolina. But you can do all your own stuff pretty much on your own. We actually put Trek planks over our concrete slab step. I like the Trek deck stuff. That looks good. Ladybug's Mom gifted 5 memberships. You guys are amazing gifting memberships today. Thank you all. I think Ricky C gifted memberships there just a moment ago, and I know Only Funsies gifted 20 memberships before that. I think, let's see, Lindsay Ross gifted membership. Sloth Life gifted 5 memberships. Teresa gifted a membership. Only Funsies gifted 5 more. Let's see. Yeah, you guys have been amazing. Absolutely amazing. Thank you. No permit needed if no one snitches. Do the fancy concrete that gets cool finishing. Okay. Part of me, I mean, I'm literally on the border of the historic district. My house officially is not on the list. It's not a historic registry house, which saves me a bundle of money, quite honestly. But my neighbor's house across the street is. Part of me really wants to have the sidewalk torn out, like all the concrete torn out, just so I can metal detect the pathway up to the front of the house. Because this was a doctor's office at one point. There were people pulling up, in their buggy, drive the horse and buggy up to the doctor's office with a gold coin in their pocket to pay for whatever service they needed in the upstairs doctor's office. And there's going to be treasure underneath that sidewalk. So part of me wants that. Would it be enough to pay for the removal and everything? Probably not. Probably not. You can rent tools. I need to rent the experience is what I need. Where can I get that? Let's see. The HOA Karen will be watching. I don't think we have any HOAs in my town. Maybe some of the newer areas do, but we're in the old part of town that doesn't even know what HOA meant. So you have to rip it up to do the steps. Go price wood. Crazy. We do carpentry as well. It's nuts. Lois, good afternoon. Welcome. Tumwater Troy. There's probably a video on YouTube. There is. Misconduct member for 35 months says, not much to say except you really dislike Kouri Richins, and I hope she gets what's legally allowed. OG. Misconduct, thank you very much. Congratulations on 35 months. Precast significantly cheaper, like $200 a step. But like 9 foot long, can I do that? You find bones in your yard yet? No, as a matter of fact. At least not any human bones. Snake bones, squirrel bones, that sort of thing. Chicken bones. My first home was built as the church rectory. When we tore off the back porch, we found the secret stash of alcohol empties. Those bottles are amazing. You know, sadly, my friend who passed away, who helped me with the chicken coop, he would be the one that I would go to and say, "Hey, can you help me with the steps?" He built fences. He ran a fencing company, but he could do any concrete work. He was amazing. We had to cement our steps for insurance company for safety reasons. It was easy, just re-cemented the tops. This is the tops they're sealed mostly because they're painted so many times. Our steps are painted green, not the color of roof green, but just a different color green. And so the steps themselves the surface is fine. It's just the whole thing has sort of tipped backwards and cracked in the middle, sort of leaning in. So it's not safe. It could print it, but it would take forever, and I need so many spools of. I just got 2 more spools for my son. He's trying to print something big. He's like, I need more white. Got him some more white. So happy I ran across this channel. I'm glad you're here. Coffee with Cupcakes. Thank you very much. Welcome. Got a couple minutes here before the judge comes back. They're going to continue working out these details that they're going to read to the jury in its fullness on Monday before they start deliberating. It sounds like right now we're about an hour, maybe an hour and 15 minutes of jury instructions, which is long, but we do have 5 charges, so that makes sense. But depending on how much more there is, that's what I'm expecting on Monday. Just replaced my electrical box. Some money. Try replacing the electrical cable, like copper. That heavy gauge stuff that comes in from the street. That's a pretty penny per foot. Yeah, we lose the good ones. I'm sorry, well. What time are we resuming? We're resuming in about 10 minutes. The judge says he'll be back in 10 minutes. He's taking a little bit of break, and he's reworking a couple things, fixing a couple typos, and we're going to be back. You all hear that Judge Fleischer is back on YouTube. I need to double check that that's his account. I saw the account, but I'm not sure if that's really his. I don't remember what it was before, but if he is, I would love to go back to seeing what he does, because he's a hoot. Love watching him. He's the guy who says, "Happy birthday, you look good," and he wears a bow tie. You don't want wood steps. They don't last, and you will have to do them over and over. Cement can do once and be done worth the money. I hope I'm not putting the cart before the horse here, but we are intending to move, but I don't know where to yet. That's our goal. We're looking to get into a house that is not actively crumbling to the ground around us. That is what we like to do. Plus, we've we've got kids that are moving out. Our family's shrinking. We've already lost 2. We're about to lose a third. We don't need as much space as we have now, which opens up the possibilities for houses because prices are nuts. So we can, we can get a smaller house that meets our needs, which gives us a lot more flexibility as to where we go. We want to be closer to family, grandkids and everything, but we can't afford all the way where they are. So somewhere in the middle. The Midway Mansion, that was actually what I suggested to Mrs. R.A. Unfortunately, it's not on the market. The people that own it are still hoarding it for some reason. But R.S. Amber, thank you very much. We've loved following this case. Even when I was out there in person for a couple hearings, we've been following this one since early on. What's the next case? The one that... let's see. The one I'm looking at next, as far as the next big one, hang on one second. Fitzsimmons. Fitzsimmons looks amazing. We'll see. We've got to do some work there. I know I have a 4-bedroom home, kids all grown. I'm thinking a camper on the back of the truck. Okay, Mrs. R.A. vetoed that. I said, there are people who live in an RV, and they can live wherever they want. They just travel around and park and rent the spot they park in. She said no. So, only funsies. How many memberships do I have to give to fix your steps? The price this guy quoted, about 4,000. We've got another quote coming. So we had a quote that was like almost a third of what this guy quoted us 2 years ago, and at that time we didn't have that. We couldn't have afforded that price, and so we couldn't do it. But yeah, we're waiting. Get a better quote. Yes, to Fitzsimmons. I have just started to peek under the the cover sheet of the Fitzsimmons trial, and it's got firefighters. It's a murder trial as well, I believe. It's got some good stuff. If you know a few details, summarize it. Yes, Big Sky. I think you are one of the people that tipped me off. I know Lady Draconis asked if we were going to cover it. It's not an easy recap, a lot going on. There's a lot to it. It looks like a really fun trial. You do realize you have to redo the new house's kitchen for Mrs. R.A. I'm letting her choose. She chooses the kitchen. She gets what she gets, and she doesn't throw a fit. That's how it's going to be. $5, R.A. calls her Kouri Fitzsimmons. That's a safe bet. I would say Tyler Robinson won't be until next year. That's probably... Well, aren't they pushing for speedy trial on that one? I don't remember. I thought they were pushing for speedy trial, which might get it a little sooner. Depends. Let's see. Happy wife, happy life. This is secret to success. Selena says, I think I might stay up in Park City on Sunday night so I can get there even earlier on Monday. I'm just kind of nervous about the crowd. That's a good idea, Selena. Maybe an Airbnb in Camas or something. I don't know. Have someone frame around your existing steps to create wooden steps. No need to remove them. We could do that. I just don't know. I don't know what they would attach to. Oh, Fitzsimmons is assault, not murder. That makes it even better. Because then we can make jokes and stuff. Because if it's not a murder trial, it's a little lighthearted. Sloth life. It'll all be in the disclosures. It'll be in the disclosures. We'll show them the before picture of the kitchen with the 1950s General Electric stainless steel 12-foot long all-in-one kitchen. We'll show them the before pictures and then it'll be good. At least you're not on a wetland. We're actually on some of the highest land in our town, elevation-wise. 61, 62 feet above sea level. It's a sad story. Okay. Maybe I got confused with my stories. So if it's not funny, obviously we won't make jokes about it. Cop shooting a cop, but I don't think anyone dies. I know there was a firefighter involved, but maybe I was getting confused. You don't want this house. You don't want this house. Are we moving? Eventually. Maybe sooner, but that's one of the reasons why we're redoing the roof. Kelsey, thanks for taking a deep dive on that one. Did you sell the GE kitchen or do you still have it? Mark, I'm sorry I have to say this. We took it to the dump. We dumped it. It's like garbage. I tried to sell it. Here's what happened. When it shorted out, and it was covered by insurance, because my son had flooded the kitchen with plugged the sink, turned the water on, shorted out the GE appliance, the kitchen center. We called GE. GE did not remember that they had made it. They asked us for pictures and model numbers, and they were amazed that this still existed. The GE, General Electric, had made the cabinets, like up on the wall. They were like yellow and green. They had made the refrigerator freezer, which also hung on the wall like a cabinet. This says hangs on the wall like a picture. They had made the entire bottom, so it was a matched top and bottom set in the entire kitchen with this 12-foot long one-piece stainless steel top, dishwasher, stove, sink, cupboard, Lazy Susan, all of it, all in one. When we tore it out, because we had to because the floor was ruined, we called and got prices on it. There was one for sale in California for I think like $65,000 used. Insurance said no way, we'll replace it with new stuff. I put it up. I'm thinking somebody might want this. Somebody will try to fix it. I put it up on Facebook. I tried to get it to sell because we were doing all the demo ourselves to save money. And I got a couple calls. One person was like, "Oh, I'm in California. I'd like to buy it. Can you hold it for me?" I'm like, "We can't. It's huge. It's massive. It's going in the bin, and then the bin's going to the dump. So if you want it, you can come get it." And it weighs a ton. He couldn't get it, and we had to scrap it. So let's see. Detectives, I don't know where we're moving to, but we're probably going to move. Like maybe even this year. We've got a grandchild coming, and we're on the other side of the country. It's not working. Yeah, I would go to Camas or something. Look for a surrounding area. So the benefit of moving out of state, we benefited greatly because our house had increased in value so much. When we sold, we could buy this house, pretty easily. The problem is now the houses back there have continued to go up in price. We can't afford to move back, so we've got to find somewhere in the middle. Another road trip, possibly. Not looking at going back to Utah. I'm not against. Well, I am against Idaho only because their fishing rules are broken beyond broken. They're terrible. Their laws about fishing, the laws in Idaho about fishing, if you like fishing for trout, which I love, are written in such a way to make sure that everybody is a felon by the end of the fishing trip. It is impossible to follow the rules and fish at the same time in Idaho, because literally it's like, well, if you're facing upstream, you can do this, but if you're facing downstream, you can't. And every 50 feet, the rules change, and you catch a fish up here, and you have to be able to prove that you caught it on this stretch of the river, because you walk 10 feet further down, now you're in possession of an illegal fish. It's nuts. It's nuts. So, anyway, please stay in the Eastern time zone. We would keep following cases, a lot of Eastern time zone cases. So I just have to get up earlier. Residents too. Yep. Your residents and non-residents, it's the same. It's the regulations on the body of water that's crazy. West Virginia is beautiful, every part. We've looked at West Virginia, Candy. As a matter of fact, before we moved to North Carolina, we nearly started a business in West Virginia doing the Hatfield-McCoy Trail system, supporting that infrastructure. I think we were in, I can't remember the town's name. We were looking at 70 acres in West Virginia, pretty much adjacent to one of the trailheads for the ATV system, and you're allowed to ride your ATVs around the town. And we were going to build luxury yurts, so for camping for ATVers that are going through and need a place to stay. Didn't work out. Maybe later. Just no HOA. Oh, there will be no HOA. We're not doing it. I don't care how good the deal the house is. We're not going there. Just think of all the wacky court cases in Florida, though. I know. We're working on the technology and the equipment to be able to get court cases from anywhere and make it easier for us to send somebody to court and bring the feed to you. That's what I'm building. Northern Arizona is cooler and lots of fishing. Would we cover Rex Heuermann? Maybe. That one is a murder case, I believe. Multiple. I really like the idea of the Texahoma area, Oklahoma-Texas line, which is not far from Thomas. He's down in Texas. I'd be up in Oklahoma-ish, which is, the neighboring state. We're avoiding the Clenny case. Courtney Clenny is a very interesting case. The problem we have with that one is a lot of the evidence is going to be some of her material from her OnlyFans channel. And even if the video's not shown, the audio alone could get us in deep doo-doo with the YouTube powers that be. So it's possible that once that trial starts, we get an idea for how they're going to present that evidence. It could be something that's picked up and watched, but honestly, most likely not. It's just, it's too naughty. Though it's spice. It's spice. Shelly Small, I love Ohio because we can get all 4 seasons in 1 week. It's a bit of a wild trial. It is. Allie, that's what I'm saying. If it turns into something that is not OnlyFans focused, it could be an interesting trial with a legal battle that is worth watching. But if it's basically just a 2 or 3 week long advertisement for her OnlyFans channel, we're not going there. Blue Star says I can vet it for you. Thank you. Give us the lowdown. All right, it's time for the judge to come back. He is actually 7 minutes late. He's been gone for a while. We did a poll, see clearly. We did. 72% said guilty on this one. 72, which is not as high as maybe the state might want if we're similar to what the jury would think. Stay in North Carolina, move to a different part of the state. I have loved North Carolina. It is beautiful. I've loved being close to the beach. It's the first time I've ever been close to a beach. The metal detecting, the sandy beaches, OBX. Oh my goodness. North Carolina keeps that a secret. You guys think that Florida beaches and stuff are great. No, OBX is where it's at. It is unbelievable. All right. Thought no court today. The only thing that's happening in court, the jury's not here. But the judge and the counsel for both sides are, both lawyers are working out the jury instructions and possibly the rules about closing arguments. So we're sort of waiting. I think the last thing the judges covered just briefly was the verdict form, and he was making some corrections and probably printing right now. So hopefully he'll be back in just a second, and we'll get that wrapped up and get plans for Monday. Any news on that Kentucky sheriff judge case? I haven't heard anything recently. They keep having hearings. He's still in custody. That's all I know. What about South Carolina? Beautiful state. Very beautiful. Loved it. I've only been there. I've only driven through a couple times. Spent a couple days down there for doing the hurricane cleanup, and I've driven through when I headed to Florida that one time. But just beautiful. Amazing people. My daughter's husband's a Marine. They live in North Carolina near Camp Lejeune. Nice. Not far. Outer Banks have those huge storms. That's why we're an hour and a half from the Outer Banks. That keeps us far enough back that, we really haven't had any trouble from the storms. Man, you guys are suggesting a million trials. It all depends on the schedule, really. The schedule is number one as to what we can follow, because we always want to be following a trial. Number two, we need content that won't jeopardize the YouTube terms of service. So obviously, like the Courtney Clenny case has a high risk of showing something that would be extremely inappropriate and might get me. I mean, YouTube does a one strike and you're out policy on some things. And if there's a mistake made there, it could be quite permanent. So I don't want to risk that. We also don't like doing things that we've found over the years are just really hard for this community to watch. We don't like watching murder trials involving, just kids being treated horribly. It's not fun. It hurts to watch, and it just gets heavy, and people come in, it's like, I just can't be here. It's too depressing on my soul. So we try not to do that. We try to keep just the lighthearted regular murder stuff, which is a little easier. So we put those filters on everything and see what shakes out. Is Georgia a beautiful state? Do you know of any wonderful people there? The problem about Georgia is I think I'm banned from Georgia. All right. We do like the fun trials. We like the interesting trials. We like trials that have good lawyers, good judges, good audio. Honestly, audio, I do what I can to fix it, but the better the audio is, usually the better the trial is. Lots of fun stuff. Let's see. Band do tell. There's just a soundbite we play. I'm not sure what it is. Is it exclamation GA? Is that what it is? I think it's this one.
You You are banished from the state of Georgia.
That one. So the devil may go down to Georgia, but you can't. We're banished. The judge said he can't come here. No, not really. I could go there. Georgia just scares me a little bit. We had a couple trials in Georgia that just seemed like it's like, oh, be careful down there. They don't mess around.
I think I'm about to catch a whooping.
Just read where the sheriff, the Nancy Guthrie case, just got hit with $1 million lawsuit. From who? The sheriff down there. I know we got. I still got notifications from Pima County down there in Arizona about the
Remember in the beginning when we started 110 years ago?
I remember that. But there was one update where the update on the investigation was answering questions about the sheriff's resume and how they had updated and corrected some things that were wrong about his years of service. Like, okay, if some of you have noticed that the sheriff had a mistake on his resume or his CV, and we've made the corrections, and here's an explanation as to why. That was the whole update on the investigation one day. It was unbelievable.
You are banished from the state of Georgia.
Yes. I need to chop that E off the end. Is Georgia the state that takes forever to drive through? North Carolina is pretty bad if you're going from east to west, the full length. Well, there's a couple of them. Especially once you get further west. It gets long. It's a long trip. So the map looks small. It's a long time. It's a long drive. Move down to Texas. That's an option as well. I've got family down in Texas, and friends. Kurt's down there. Thomas is down there. Goodbye, Karen Reed's old house. Or Kouri Richins. See clearly, did you do a poll? Yes, we did. It was 72% in favor of convicting Kouri on the charges, with the balance in saying the state had not proved it, or she was not guilty. What time are they back? I forgot. They're back 14 minutes ago. Alley Cat. Strongly pleading to cover Kelsey Fitzsimmons. She's got a great attorney, great judge, possible bench trial, spicy witness drama. Mathis, we're looking very closely at that, and it looks good. It looks good. Amanda says, I'm in Texas. What more could you want? Yeah. I can tell you what I want. I want enough land that I and my grandkids can ride the four-wheeler in the back of the house. I want water to be close enough that I can fish on it without having to, rent a hotel or camp somewhere. Realistically, my age, probably rent a hotel somewhere to fish it, and make it back home safely. I know there's a lot of water, especially up in northern Texas area. I'd prefer to have clear water. I love clear water trout streams. You get those in the mountain areas. See, the water here out in North Carolina is just muddy. It's all stained. It's brown. You're getting older. You need to live where you don't have to be airlifted to a hospital. Okay, these are thoughts that I should probably work into it. Move to the Black Hills. My sister-in-law moved to Texas, and she's enjoying it. I've also got one sister, two sisters, three sisters in Texas, possibly a brother, I think, who's just moving down there as well. So 4 siblings in Texas. Selena says, okay, I just booked my room. If I get there first Monday, will you make me a trophy on your printer? We're working on trophies. We were planning on doing it for the end of the year for the awards, but we'll see. Better to live by a lake than a river. Rivers flood. How about all the rivers in Tennessee? Tennessee was pretty. Driving through, it was very pretty. I didn't get a chance to stop a lot and check it out. I had a buddy who moved. I did some filming work for him out west before I came out here. He moved to Tennessee. He bought like a ranch. It was one of those. He was the corporate guy working in the office, running and gunning, working his way up the ladder, and he sold it all and went and bought a farm in Tennessee and bought a tractor, and he's like clearing land and just completely changed his life and loved it. But he did that for maybe 3 years, and then he moved to Atlanta and started a business again, and he's doing well down there. But absolutely love OBX, better than Florida. OBX is a secret that I think too many people know about, but it is beautiful. The people that come to OBX come back, and they come back, and they come back. It is amazing. Becky, I have not seen for sure any of Kouri's outfits in court in the closet images that were shown. I looked for a while. This last one, I couldn't find it either. Not in the closet. So I don't know where she's getting the clothes from, but not her closet. How many siblings do you have? Well, other than me, 9. There are 10 kids in my family. What's OBX? Where is OBX? The Outer Banks of North Carolina. Basically, the furthest east you can go in North Carolina. The little row of that little narrow strip that runs out next to the ocean, the Barrier Islands. I'm right about the middle, Laura. Verdict on Monday would be highly unlikely. I agree, Jason. There's just a lot to the instructions. I'm thinking Tuesday would be fast. Wednesday was probably more realistic. But OBX stands for Outer Banks, and if you're in North Carolina, the license plate you want says OBX on it, and then any other numbers. You just want OBX somewhere. That's the plate to get. It's hard to find a OBX plate. You fell in love with Inglewood, Florida, by Venice, which I do love. In 22, first time to OBX and loved it. So laid back. It's amazing. And if you have a boat or rent a boat, or hire somebody to drive you around on OBX, you can go out to islands that just people don't go to. There's just nothing there. You just beach the boat on the island, and you can go shelling and pick up just incredible shells. Not just like the broken pieces you get on the West Coast. Like you can pick up a piece and try to make out, so this used to be a clam. Nope. You can find just amazing specimens of shells everywhere in OBX. Maybe they're there in the Cameron Split. It is Friday after all. Arkansas is beautiful. We've looked there. So Colorado or New Mexico to be in between Utah and Texas. I worked a lot in Colorado. I used to cover the western slope of Colorado, and sort of Grand Junction area. As far as I think it went as far as Vail east, but Colorado hasn't really called my name much. I know they've got some great fishing. There's actually got some cool mineral stuff up there when you get up to the north side of the state, up by Wyoming as well. Can't have an OBX plate unless you live in OBX. My parents live out there. They're all gone. I mean, you want to get one as a vanity plate. That's the only way you can get around that. But like OBX lover, I think a local here has OBX lover on it, spelled interesting way. But have you lived in many different states before? No. my wife's lived in a couple states. I've visited a couple states, mostly out west. I've been Utah, Idaho, Nevada, or Utah, Idaho, Nevada, Colorado, Wyoming, Montana, Oregon. I haven't even really been to Washington much. California. Love you, bye. Traveled but not lived. Yes. I like to research the laws. There are just a few things that are deal breakers for us when we're researching where to live. Obviously, we homeschool our kids, so that has to be legal. So in that regard, Alaska is great for homeschooling. It's almost too good for homeschooling. They don't care if you homeschool your kids or not, or if you teach them anything. They're just wide open, do what you please when it comes to that. I'd like a little more structure than that, but Mrs. R.A. does not like the cold, so we'd have to be in like the Pacific Northwest corner down by Washington, that big long part that goes down the side of Canada. I'm fine with that, but it's basically it's a very rainy area up there. Arkansas has the White River too, best trout fishing. Where's the White River at? Homeschool is legal in all states, but some states are much more difficult to do it in. As a matter of fact, I think there are some that require you to, if you want to homeschool beyond a certain grade level, you have to have a certain teaching degree. Like in North Carolina, for instance, they were required to take attendance. They're here every day, but we have to take attendance. We have to keep that on hand. We have to do annual testing and have testing results, turned in and stuff like that. We like states that allow us to be a little flexible. I mean, we love educating our kids, and our kids love going to college, and they get in. They get in usually and do very well in college. So we feel that how we homeschool them is working, but we don't like the states that basically say, "Oh, you can homeschool, but you just have to pick up a copy of the textbooks from the school and teach everything exactly the way they're doing it." So we're just a little picky that way. Mrs. R.A. is a great teacher. Try Texas. Texas is good. Why do you end up in North Carolina? We just felt like this is the right place for us right now. It was literally, we put all the states on the map and just started crossing them off for different reasons. North Carolina came to the top of the list. I put we found 9 houses in North Carolina that fit the size we wanted and were either not right next to a hog farm, because we didn't like that, not so close to the ocean that we would get blown away with every hurricane, and I forget, there was one other stipulation that we looked at like a tornado map of places where tornadoes like to go, and then we found these 9 houses. I flew out here. The first 9 houses I looked at were terrible, like bait and switch. Like, this is not the house that you had pictures of online. The 9th house was this one. I fell in love with it immediately. Called Mrs. R.A., said this is the one. She said, okay, buy it. She had never seen it. And that's when I lost my house choosing privileges. But we sold our house in Utah, sold our car in Utah, got a ride to the airport, shipping everything on a shipping truck across the country, flew across the country, landed in North Carolina, took a rental car from the airport to the closest car dealer we could, and in a torrential rainstorm, bought a car that would fit the whole family, which we still own. Drove to an Airbnb close by that night, and then drove to our house, and that's when the first time my family saw the house ever. And none of our stuff was here at that time, so we got to sleep on the floor. But basically, it's like throwing a dart. But it just felt right, and it's been amazing. I've loved working out here. I've loved living here. Just met incredible people. I mean, when they say Southern hospitality, I didn't know what that meant until I moved out here, and it's great. Good people, good food, great weather. I mean, barring a couple tornadoes and hurricanes, which so far have not done significant damage for us. Here's the judge. It's been wonderful. We're back.
Okay. Mr. Burmester, do we need to wait for Mr. Bloodworth?
No, Your Honor.
All right. Let's, Ms. Nestor, go back to your submission this morning. We'll use that as a list here. First, with respect to defendant's request for an instruction or addition of an additional section to the witness credibility instruction regarding Detective O'Driscoll having had an opportunity to listen to all the prior testimony, and that instructing the jury that they may consider whether that opportunity to hear prior testimony enabled him to tailor his account when determining his credibility. The court has re-reviewed Portuondo versus Agard, 529 U.S. 61, U.S. Supreme Court from 2000. That case stands for the proposition that it is not improper for defense counsel to make that exact argument during its closing. But it does not stand for the proposition that it's appropriate for the court to give that instruction as if it is a precept of law. So the defendant's request for a jury instruction to that effect is respectfully denied, notwithstanding the fact that you'll be free to make that argument. Anything further?
No, Your Honor.
Mr. Permister?
No, Your Honor.
Okay. Then let's look at the first 2 pages of the additional instructions that I sent out. Page 1 is a proposed instruction called informant. It comes from the 10th Circuit pattern instructions. Page 2 is a instruction titled immunity. It comes from the 10th Circuit pattern instructions. I propose that we use these 2 pages in this form, which are not specific to any individual, and use the pronoun they.
No objection.
In place of Muji second CR 415, which is the custody informant. Mr. Burmester.
The state objects to number 1, informant, because there were no informants in this case.
Well, tell me why Carmen Lauber doesn't fit squarely within the first sentence of this instruction.
The reason she is providing evidence, arguably, for a defense might argue, is because she was given immunity, which is why I don't object to number 2.
Didn't she also indicate in her interviews, though, that she was doing it based upon her sense of personal accountability for having been involved in this situation?
Yes, but that doesn't make her an informant. She testified, both she and Crozier testified to the events they saw. Frequently, in many prosecutions, the government has to make a choice of who to charge and what to charge. And sometimes in order to proceed on one prosecution, you got to give up another one. And that's what we have here, is in order to bring to bear what the government saw as the more serious crime, that is what the state believes is a murder, we had to have those eyewitnesses be able to testify. In order to do that, we had to provide them immunity. I don't think that makes them a fortiori an informant.
Draw the distinction for me. What would you see the informant as being?
I believe an informant is someone who is privy to some statements or some other source that's not directly involved in the crime. So, a cellie who overhears something that a witness or the suspect say. They don't know anything about the case other than what they've heard somebody say in the jail or at a drug deal or whatever. So that's, and I think that recent experience over the last decade or so, I think the courts were very concerned with that type of testimony for obvious reasons.
Let me spin a hypothetical here related to the facts of this case, but not from the facts of this case, to make sure I understand your position. So it sounds like if somebody heard Kouri, or somebody came to law enforcement and said, I have information that might be relevant to the Kouri Richins case, but if I give it to you, I need a break on my probation. And they work out some kind of deal. And then they relate that Kouri Richins, once upon a time in 2022, in January 2022, asked for me for fentanyl. And I'm willing to testify to that effect. But if I do that, is that the kind of situation you're referring to?
If we alter that just a little bit, the defendant, whoever it is, told me something, they killed somebody, or they shot the gun, or whatever. That, I think, is different. That's not a witness to the crime. I think if the witness had said, the defendant said they bought drugs, fine. But if the witness is witnessing the event, I think that makes them, that's the distinction that I would draw.
Okay. I understand your position. Ms. Nestor.
We have no objection to the new informant instruction or to the making the immunity instruction just general. We're fine with both of them.
Tell me why you believe an informant instruction is necessary, though. There's no dispute regarding page 2, so we don't need to talk more about that. Mr. Burmester is taking the position that as a matter of law, it's inappropriate to give an informant instruction because, if I understand him correctly, Ms. Lauber and Ms. Crozier, in his estimation, simply do not qualify as informants. Tell me why you believe they do.
The reason, well, I think they're clearly informants. I don't understand the distinction he's making at all. There are people that gave information and got a deal out of it, whether... I just have never seen that distinction made in the past, so I'm not sure I understand his distinction. But the reason I think you need both is because the immunity instruction only deals with the motivation of the grant of immunity. The informant instruction deals with other motivations, such as to get out of drug court, to be able to send texts to Mr. Maynard instead of having to get, urine tests,
travel to Nevada,
to make herself feel better because she feels guilty. All of that is not covered by, those are all benefits to her from providing information that can cause a reason to be suspicious. So I think they're both necessary. That's all.
I understand your position. May I ask you a different question? I don't understand the relationship between the first sentence and the last sentence of these two instructions. They seem internally inconsistent. Now, mind you, they are the pattern instructions, and so presumably some committee of 10th Circuit lawyers has come to grips with this, but
that is the last sentence is dealing with the scenario where they find no other reason to find guilt other than this person's testimony.
But isn't that exactly what the second sentence in the first paragraph is talking about?
Yes.
It can be. Oh, I see what you're saying. The second sentence. I was looking at the last sentence. I'm sorry. The testimony of an informant alone. Well, if you believe it beyond a reasonable doubt. That's what they're saying. They're saying that you can't, if there's no other reason for you to find her guilty other than this person's testimony, you need to believe it beyond a reasonable doubt.
Okay.
And that's why that's there.
So you'd acknowledge that you wouldn't be able to say, well, you can't convict based upon Carmen Lauber's testimony alone.
No, they certainly can.
You'd have to add some language to that statement.
Correct. Absolutely.
Okay. All right.
Absolutely.
Anything further, Ms. Nestor?
No, sir.
Okay. All right. Counsel, with the benefit of your argument and having had time to consider it during the break, the court finds that based upon its consideration of the evidence that has come in this case, specifically regarding people like Carmen Lauber and Robert Crozier, that it is appropriate to give the proposed instruction entitled informant that comes from the 10th Circuit pattern jury instructions that is indicated on page 1. In addition to the pattern jury instruction from the 10th Circuit titled immunity, which is on page 2 here, based on that ruling, the court will not be giving any version of model Utah jury instruction CR 415. Mr. Burmester, any further record there?
No, Your Honor.
Okay. Then, if you would please turn to page 3. This is a revised other acts instruction.
The one he's not going to read
2
is
questions.
The in-custody informant one.
First, in the bulleted list, do we want to add any mention of the defendant may have been involved in civil litigation that she referred to as charges? Or do you want to just leave it alone? Ms. Nestor.
No, I think you cured that when it happened, and I think bringing it up now would just bring unnecessary attention to it.
Okay. Any objection to that, Mr. Burmester?
No.
All right. And then, Mr. Burmester, if you'd look at the 1 to 3rd paragraph, I've added some, though not all, of the alternative purposes from Rule 404B. I've added the ones that I think have at least minimal factual foundation in this evidentiary record. Any objections, sir?
No, that was our request.
Okay. Ms. Nestor, any further record there?
No, Your Honor.
Okay. Very good. Okay, turn to page 4. This is the aggravated murder instruction. I collapsed. Oh, I got to change the numbering. I'm sorry. This is why we go through these things together. All right. Bear with me for a moment. The elements are 1, Kouri Richins. 2, intentionally or knowingly cause the death of Eric Richins. I collapsed that for a reason you'll see in a moment when we get to the attempted instruction.
Okay.
3, under one or more of the following circumstances. And then in the second to last paragraph, instead of element 4, it'll say element 3. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
Nothing additional, Your Honor.
Okay. Then if you turn the page, I needed to put the word, the modifier attempted to before intentionally or knowingly caused the death of Eric Richins to make it clear, Ms. Nestor, that you don't have to intentionally or knowingly attempt. You have to attempt to cause.
Yes.
Okay.
I believe that's right.
And so that's why we switched those around.
That's better.
Any objection, Mr. Burmester?
No, Your Honor.
Okay.
There's italics on the last couple paragraphs. Is that for a purpose or?
You know, it was supposed to be beyond. No, that is something I just need to edit to match the original. I know what you're going to say. It's going to say circumstance or circumstance is on page 5.
Also, I just caught by looking at that on page 4, the one before, it should say listed in element 3.
Correct. I made that.
Did you catch that?
I did.
Okay, perfect.
Thank you.
Yep.
All right. If you would turn to page 6.
Okay.
Elements of insurance fraud, count 3. Ms. Nestor, I understand defendant's argument. Based upon the plain language of the statute under which count 3 is charged, I think elements 1, 2, 3, and 4 are correct as a matter of law as applied to the evidentiary record in this case. Defendant's request for additional elements language is respectfully denied. Any further record there?
No.
But I think it is important to instruct the jury explicitly about what act the state alleges or believes Kouri Richins performed or committed to commit this crime. This is a starting point, a proposal. I'm not the state's lawyer. I just put something in there to get the conversation started.
This is where the state has to say, this is what we think she did. And this is a slippery slope because they
I'll
might.
let them talk first because I'm interested to hear what they say.
I don't think they're going to like this.
Other than Richins
got it.
spelling, I think that's what we're going to argue is what happened.
Okay.
So, and this may be more just for Ms. Lewis's benefit, who's listening in, because she'll be doing the closing, but I am unclear why submitting the application or making the claim or receiving the money is fraudulent.
Because in the state's theory, and what I understand they are intending to prove beyond a reasonable doubt, is that the application was fraudulent and therefore was void ab initio.
Because of the forged name?
Because of the forged signature from Eric Richins.
So in other words, the crime is getting someone some life insurance they didn't want, because they both applied. You know, she applied for herself and him.
Well, I think what the state's going to show is that she submitted an application that she forged the decedent's signature, listed herself as the beneficiary after he died, as submitted for the claim, took the claim. Now, count 5 is the signing, right?
Right.
Count 3 is the devising of the scheme to get the money by signing, submitting, making the claim.
So my concern...
Do I have that right, Mr. Permister?
Yes, Your Honor. It's just
Go ahead.
like frequently there is when you have a forgery, there's a corresponding count, like a theft or theft by deception, whatever.
So the only issue I have, I have some issues with that, but the testimony of the True Stage lady, I'm so sorry I cannot remember her name. I don't mean to be disrespectful. I just cannot remember her name at the moment. Maybe Coates. It might have been Ms. Coates. I'm not positive.
It's Ann Coates.
Okay, good. Ms. Coates. Was that they did not ever investigate or follow up. When they would get an application, they didn't call the person and say, is this your signature? Is this okay with you? That was not something that mattered to them. So we know that Kouri had a right to apply for the policy for herself, clearly, which she did on that policy. She applied for both of them. It was in both their name, like each other is the beneficiary. So they each were getting a policy.
Right.
So.
I'm saying right. When I say right, I'm saying I understand what you're saying.
Yeah,
I'm
right.
not making a finding.
Correct. So I don't understand how, if the claim on the death is based on a death that actually happened and it's a policy they agreed to approve. Once they approved the policy, they approved it. So whether or not...
but I think the state's theory is there was a threshold intentional misrepresentation in the beginning. That is that Eric Richins signed this with the intent that Kouri Richins would be a beneficiary on this policy. And the state's theory is that simply just never happened.
You can purchase insurance and put yourself as a beneficiary on behalf of someone. Like I could right now get life insurance on my husband where I'm the beneficiary.
Yeah, but you can't forge his signature on it.
Well, if she had authority to if she had authority to sign his signature.
But that's a big if. That's in factual dispute in this case. We're just talking about legal elements here. Sounds like this will figure prominently in defendant's closing argument.
Yeah, I guess so. Okay.
Mr. Burmester, besides the spelling error, any...
Wait, before we go on, can I just
sorry.
get a clarification? So I can argue. I'm just concerned that if this language is in this instruction, that I'm not going to be able to get up there and argue, this may be their theory, but we don't think any of this is a crime.
You can say exactly that.
Okay, just making sure.
You can say the state had this theory and didn't prove any of it.
Okay. And it does start with the state's theory.
Right.
I just feel like you're telling them in an instruction that that's a crime. That's what's bothering me, right? It's like it sounds like the judge is telling them this is a crime.
No, well, I think this is, in my mind, and you tell me if there's a more artful way to do it in your view. There are times in sexual assault cases, for example, where multiple touchings happen of different body parts, and you've got to be real specific in the counts. The state's theory regarding count 2 is touching of this body part on this day. State's theory regarding count 3 is touching of this body part on that day, to prevent any ambiguity regarding unanimity. Here, we're doing it for a different purpose, but we're providing specificity regarding the state's theory so that it's clear the state is asserting that she did something other than think.
Well, can we put what our theory is? I mean, I just don't.
But you don't have any burden.
No burden and no witnesses.
But we are entitled to theory of defense instructions. I mean, if you're going to put their theory in, I just think adding that part on the bottom is problematic for a lot of reasons. I think just like with all the other instructions, they can stand up and say what they think meets these 4 elements any way they want. But if it comes from you, it's like you're saying this is sufficient.
I can take it out if you want.
That's what I would like.
Okay.
Okay, perfect.
Mr. Burmester, any objection?
No.
Okay. I imagine they're going to hear the same thing or something similar in closing, so we'll end up in the same place.
Except now we're back in the position where they could convict her for just thought.
Well, we were probably in that position by virtue of the Utah legislature when we walked in here today, so I don't know that we're going to fix that in this case.
I mean, there's evidence that whether they believe it or not is another question, but there's evidence that Kouri Richins filled out an application for insurance, submitted it to the insurance company, and they eventually paid it out.
I don't disagree.
So
whether it rises to the level of a showing beyond a reasonable doubt of the elements of this crime, the jury will determine.
Absolutely. And I think the only thing that did to help, I mean, because we're not arguing that a bad thought came into her head. That won't be argued. But it does help us distinguish unanimity between 3 and 4. That's the one.
Well, I think also the dates.
The dates are different. Yeah. Absolutely.
But what if we did this?
Yeah.
Just to create an actus reus, because I don't think one exists in this instruction. What if it says intentionally, knowingly, or recklessly devised and enacted a scheme or artifice?
You got to talk to Mr. Burmester about that. I can't unilaterally add an element that doesn't exist in the statute.
Oh, I see what you're saying.
Now, you can stipulate to that if you want to create some appellate insurance, but I also take Mr. Burmester's point seriously, and I'm not a appellate or constitutional litigator, but given the evidentiary foundation and the arguments that would be made at closing, I'm not sure we actually have a constitutional problem here.
Okay, well, I guess I would just have a general objection that there's no actus reus in this instruction, but I think the bottom paragraph adds more problems than it creates, and I would ask that that be stricken, but I understand, I guess what he's saying is, don't worry, I'm going to argue it correctly, even though it's not written correctly on this instruction.
Or I think what he's saying is, even if the statute is somehow defective for not having an actus reus defined,
right,
the evidentiary foundation in the state's closing argument will make it clear that they are alleging that there were multiple acts committed here.
Okay.
Is that fairly stated, Mr.
Yes. We are definitely not making the argument that somehow the instruction is improper or unlawful.
Okay. Okay. And then, anything else on count 3, Ms. Nestor?
No, sir.
Mr. Burmester?
No.
All right. And then count 5 is just the skinny down version of element 4.
Did we skip? Because on count 4,
I didn't make any changes.
You left it the same. Got it.
There were no objections to count 4.
Wait. I thought count 4 was the one.
Did I miss some? I apologize.
Yeah.
Let me take a look.
Let me check.
I don't have any handwriting on count 4.
Just a moment. Okay, let's see. There's 1. Just a sec. 2.
Mine is clean as well.
1 and 2. Just a moment, Your Honor. I'm so sorry. Count 4 was the one about the fees. Wasn't that count 4? Or was that count 3?
Count 3 was the language from
That-
the statute
that had the
regarding
fees.
fees for services.
You're right, then no, there was nothing on 4. I apologize, Your Honor.
Okay. Take a look at count 5 for me. Let me know if you have any concerns.
Not from the defense.
Yep, no objections.
Okay, great. All right. I think that only, oh no, before we get to spoliation, Ms. Nestor, my apologies. Did I hand out the special verdict forms? Did I bring them with me?
Did you, the amended ones? I don't think we have amended ones.
My apologies. I'll be right back.
No worries.
All right.
Judge, almost without warning. I'll be right back. Bales, he's just going to grab a copy. He'll be right back. Just a couple moments. Love listening to opposing counsel getting along. Yes, this part, they're sort of best friends. They will be spicy again on Monday. Going right after each other. We are very close to 1,000 likes. As a matter of fact, let me just check the counter officially. And yeah, we need 7 more likes to hit 1,000 today. So if you'd like to do that, now there it is. We did it. That was really cool. Thank you. Appreciate you all. Congratulations. And then we just got 25 more. So a few of you had forgotten. I'm glad I could remind you. Thank you. Party sound. There it is. It was quiet, but we did it. Is Bloodworth doing the closing for the state? I don't know. He's not here right now, which seems like he should be. The judge said, "Can we begin without him?" And he's like, "Yeah, it's fine." So I don't think he is. Can only hit like once. Yep. So I'll do the party sound one more time, a little bit louder, because we deserve it. There you go. Darlene, thank you very much. I fell asleep, says KLB. I fell asleep during the first break to wake up to another break. Did I miss anything? This one's short. The judge is just printing something off. It'll just be a moment. He'll be back. But Ms. Lewis doing the closing for defense. That's a choice. I was hoping to see Ms. Nestor. I know we saw 3 hours of her in the open, and that was too much. But I was hoping to see Ms. Nestor do the closing. That's the lamest party horn ever. Okay, so what I could do is we could do this with the party horn. Is that better? Is that no? Okay, judges may be coming back. Believe it or not, sound effects are copyrighted. I have to be very careful where I get my sound effects from so I don't get a copyright claim for using a sound effect. We're back.
Council, we're back on the record. I've just handed you a
That's training.
revised version of the verdict form.
Thank you very much.
If
25
you would
months
just read through it and make sure I
on
didn't
the
miss
jury.
anything.
OG. Thank you. She has a lot writing on no defense. They said we're not gonna argue most of this evidence. It happens. We're not arguing the facts. We're gonna argue what the facts mean. This has been the charge conference. Just sorting out what. Is Pretty Lies and Alibis there? Is that her in the courtroom? I think that's her. Let's see.
No objections.
No objections.
Very good. Okay. Ms. Nestor, I have a list of practical things I need to talk about, but did you want to talk any more about spoliation sitting here today?
Yes.
Go ahead.
Thank you. Your Honor, may I remain seated?
Yes.
Thank you. So the court has heard in the trial that the night or the early morning that Eric Richins was discovered deceased in the bed, there was a long expired pill bottle directly next to him on the nightstand. The picture of the pill bottle has been introduced as evidence. I believe it's 1-8. I'm not 1,000% positive of that, but I think that's what the exhibit number is. If you look at the picture, you can see there is detritus or whatever the word is, residue. I'll use an easier word. Dust. Residue, dust at the bottom of the pill bottle. There was video or pictures that came into evidence of one of the first responders, Mr. Cernich, taking the pill bottle off the nightstand, and then there was subsequently a photograph that was taken, I think it was by Officer Pimentel, but I'm not 1,000% sure about that either, but one of the officers with gloves on holding the pill bottle took a photograph of it. That pill bottle, there was testimony, was sent with the body to the...
In the body bag, right?
I believe so.
To the office of the medical examiner?
I believe that is correct. And that it was delivered to the medical examiner's office. The final witness of the trial, Officer O'Driscoll, was asked if they were able to, or still had the pill bottle, and his answer was that they no longer had the pill bottle.
I don't think that
Did Detective O'Driscoll say that?
No, it was objected to because it was hearsay.
I don't know whether he knows whether they still have the bottle.
No, he doesn't know.
Right.
But he said that he doesn't have. They don't, like the Summit County Sheriffs don't have it.
Correct.
Right.
Yeah.
So I don't know if he knows what happened to it at the medical examiner's office or not.
Is there any affirmative evidence in the case about whether the medical examiner's office still has the bottle?
No.
Not that bottle, no.
Okay.
No.
Meaning no affirmative evidence, or they don't have that bottle?
They
no affirmative evidence of this bottle being present or not present.
That's my recollection. I have not rewatched every day of that testimony from the medical examiner.
Well, I do know that the young woman, and I apologize, I cannot remember her name either. I'm just blanking right now.
Dr. Ulmer?
No. The lady
Gibson?
who checked in the body that had the tag, the red tag on it.
Right.
She testified that what happens is when they open the body bag, that there are their personal effects and the prescriptions that were on scene for purposes
Maggie
of their
Mobley
giving
was her
them
name.
ideas what to test for, I guess, when they do
Maggie
the
Mobley.
toxicology. I assume that's why that's done. I don't know for sure. So I know that she did, my recollection is that she testified it arrived at their office with his personal items. I don't know that we've ever had any testimony to why it was lost or destroyed or what happened to it. It's clearly it's gone because it would have been here if it wasn't. So.
Oh, but yeah, I mean, let's come back to spoliation, right? Okay. You have to first show a violation or that a duty to preserve existed.
Exactly.
Then you have to show a violation.
Right.
Then you have to show prejudice.
Right.
So whether or not the duty to preserve existed, they preserved it because it went in the body bag with the body.
Well,
so who is it that you would say violated any duty here?
Well, it wasn't preserved for purposes of the defense to be able to examine it or to use it at trial because it was gone by the time we did our physical evidence examination. It wasn't there anymore.
I don't know that any evidence of that is in the record.
It's not.
Well, we can do affidavit. I mean, we can do affidavits as to that.
The evidentiary record for trial is closed.
No, for your evaluation purpose for the. I mean, it's not, I don't think your finding is based on what happened in trial.
No, but I
mean, because all the time on
the evidence is closed. Closings are happening Monday. To the extent you were a party wanted to make an additional evidentiary showing and have the court make findings sufficient to support a ruling that there was a breach of the duty to preserve, findings regarding the level of culpability, whether it was inadvertent or intentional, and what the prejudice is, that time was months and months ago.
No, I disagree with that. So, I mean, we could, like even now, file a motion to dismiss under Tiedemann based on what came out at trial, plus additional evidence for the court to consider. We're not doing that.
This is not that.
No, we're not doing that. But I'm saying that if we're asking for a remedy, that there was a duty to preserve under Rule 16 of this hydrocodone bottle. The hydrocodone bottle, by the time the defense team did our analysis of the physical evidence, it was missing. It was gone. So we've never had the opportunity to test it, submit it to an expert, or have it or use it at all, right? So it's missing. There's no question there's a duty to preserve it. I mean, they thought it was important enough to take a picture of it. It was next to the body. There's clearly a duty to preserve. We do not have, and I will concede it up front, we certainly don't have any evidence that suggests they intentionally destroyed it. I mean, we've just not come across that in any way. But there's definitely going to be some gross negligence here if the main container of potentially illicit drugs, of someone who was found dead of illicit drugs, is lost and made not able for us to recover under Rule 16.
You're putting a lot of freight on Maine. There were other bottles recovered in the house, but
keep
going.
Not right next to the body, there weren't. And, you know, there was an unknown dust on the nightstand right where the pill bottle was. Could have been part of that. If it was crushed or if it was snorted or whatever it was, I don't know. So the court has a lot of remedy in how to handle that, right? Like one option is a Tiedemann motion to dismiss. We did not do that. The other option is to say, hey, we would like an instruction to the jury that there was a duty to preserve this evidence. It was not preserved, and because of that, you know, you should assume that it would have been helpful to the defendant. That's the adverse inference instruction under Cronish versus U.S. So, I mean, we're simply asking the court to give us a remedy for the fact that something that was required to be given to us under Rule 16 never was.
Well, but hold on.
Yeah.
You don't have any evidence that the medical examiner's office kept it long enough for the investigators to get custody of it. That may have been destroyed pursuant to normal destruction protocols of the ME's office, along with the body.
Yeah.
They don't keep everything forever. I need more here.
Right.
I understand that this is a good faith argument, but spoliation requires findings, and it is a multi-factor analysis, and I can't skip steps.
Right.
In order to make a ruling as to whether an adverse inference instruction is even appropriate, I got to get through duty and breach and prejudice.
Right.
And we don't have that evidentiary showing.
Well, we definitely have duty. We definitely have that it's material. I think the only thing that's in question is the breach, right? Like, if, to what level of culpability was the breach? And we
Or was it breached at all? I mean, there are things such as rule-based preservation schedules that absent, for example, your client certainly knew that the body was taken, right? She had an opportunity to ask, what else do you have? Are there any personal effects? What are you going to do with the personal effects? Now, I'm not casting any aspersions. I'm just saying there are other facts that I'd have to consider.
Right. No, I agree. I don't disagree with anything you're saying. You know, it puts us in a position where we might have to have, like, if.
And to be clear, you are not limited from making the arguments you just made to me to the jury.
Oh, we will.
Where's the bottle?
Right. No, we'll definitely do that. But what I want is the inference that you got to assume it helped us.
That is, I sit here today,
Yeah.
I don't have a sufficient showing to make the findings that would be necessary to give that kind of instruction under my understanding of the law regarding spoliation.
Okay. If we're able to obtain that for you prior to Monday, can we submit that in writing?
I'm certainly not going to be closed-minded.
Okay. Thank you, Your Honor. Understood.
I'm not making any predictions one way or the other.
Okay.
Mr. Burmester, anything else on the record today?
Yes, I just wanted to add a requirement that there be a showing of reasonable probability the lost evidence would have been exculpatory.
Right.
I don't know why fentanyl would have to be stored in another opioid package. I mean, the testimony was that it came in envelopes, for example. So I would just add that to the argument.
I understand. That is among the reasons I am proceeding with appropriate caution here, given the findings that the court would need to make in any spoliation situation, alleged spoliation situation.
Right.
Ms. Nestel, you've, by proximity, asserted yourself a little bit. Maybe, do you want to talk to Fred for a minute? And I don't know that you have standing to weigh in. But
After you've resolved all of this, I just had a request.
No problem. I'm happy to hear you out in just a second. Thank you. Okay. Anything further on that issue, Ms. Nestor?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Okay. All right. Counsel, on my list, any objection to exchanging slide decks related to your closing arguments by sometime on Sunday afternoon or evening?
We actually talked to Mr. Bloodworth about this already, and both sides decided we didn't want to exchange them.
Okay.
So we're good.
Is that your understanding, Mr. Burmester?
I have no understanding of that.
Okay. I'm going to take you at your word on that, Ms. Nestor. All right.
I'll confirm it again and make sure he hasn't changed his mind. But if he does, what is the time you want us to?
Whatever you all agree to. Okay. I just.
We'll do it.
I'm inclined to order it if you folks want it. But if you've agreed to proceed in a different fashion, that's fine.
We kind of had a conversation about it when we called on 4 o'clock yesterday. And I mean, opening is different because opening, nothing's come into evidence yet. And both sides are very concerned about what's showed to a jury before anything's come in. And we were all very concerned about swapping. We fleshed that out about closing, and we all just are taking the position, we know what's in now, you can put what's in, and if you want to use some creative little thing that is just for, demonstrative purposes, the other side's not going to be able to object to that anyway, so we're fine.
Okay. With respect to exhibits, defense exhibits, Brittany has a handle on, she thinks she has all of them.
Great.
The state's exhibits, she's going to need to interact with the state's team to make sure she gets a bunch. And because the number of state's exhibit is so much larger and they're of varying kinds, there may be some back and forth about that while you're all doing your on-reading instructions and closing arguments. And so if, Mr. Burmester, if you can just make sure the state's, whoever's in charge of that for the state is present.
Ms. Steele was here trying to talk to.
She's back there.
So Brittany's not here this afternoon, but if you can keep your eyes on your email and be present on Monday morning, she'll need your help. If you want me to leave it on her desk for her, I'm happy to do it. Okay.
Also, we've been trying really hard to keep track of what we believe has been admitted, just to have a backup. So if we could just, before the exhibits go back,
yes,
give us a few minutes to make sure we're all in agreement that that's what should go back. And we have a list, we're ready to go. It shouldn't take long, but I would ask the chance to review it before it goes back.
It's my expectation that will take longer than a few minutes and will involve somebody from both sides of the V and Brittany after closing is complete.
Perfect, thank you.
Some of the exhibits are audiovisual files.
They are.
They need to be on a single thumb drive if possible, or as few thumb drives as possible. The court has an air-gapped laptop that the jury can use to view them. We'll just want to make sure that it works.
And we're fine, Ms. Steele, if you want to provide to us on box what the video ones are, so you don't have to do a thumb drive, that's fine. Just let us know what you put it on box, okay?
I think they need the thumb drive for
the jury does.
The jury, but I don't want you to waste money on us. You can just put it on box.
And then, notwithstanding our conversation regarding the 900 pages of Carmen Lauber's interviews, turns out there are a lot more transcripts that were admitted than I recalled. Several that are companions to the audiovisual files. As I understand it, there's no objection to those going back to the jury, correct? Because they're not in court testimony. They were admitted as exhibits. They're going back, correct, Mr. Burmester?
Yes.
I believe so, but I will check with that. I mean, we were, there weren't too many transcripts. Most of them were redacted transcripts that we had all agreed on, like the.
Understood. They're all portions.
Right.
For
Okay.
example,
good. I was like just
there
getting
were some
panicky.
several recorded phone calls.
Right.
All of them have
Right.
a companion transcript.
We did agree to those.
Okay.
The parties did, but now I'm panicking if there was accidentally some big transcript that slid back past us that we didn't see.
I don't think so. Brittany
Okay.
just wanted to confirm,
Okay.
based upon the conversation we had in the record, where I expressed some concern about a particularly lengthy or complete transcript getting undue influence.
Right.
She just wanted to make sure that she understood the state of affairs.
No.
If it's been admitted as an exhibit, it
goes
goes
back.
to the jury.
Right.
Yeah.
I agree.
Okay. All right.
We
Anything
agree on
else
everything
today, Mr. Burmester?
No.
Ms. Nestor?
I assume since we're doing so good and we're so far ahead of schedule that you're not putting a timer on our closings?
No.
Okay.
Not putting a timer on the jury either.
Okay.
All right. I'm going to have to do some breathing exercises before I dismiss the alternates, but it'll be all right.
I know. It's pretty amazing. We haven't lost a juror in
They
a
are a
3-week
hardy
trial.
group. And I'll make clear to them that they're not released.
Yeah.
They need to abide by all the rules in case somebody falls ill, suffers a tragedy during deliberations.
Right.
All right. I appreciate your time and effort this morning, Ms. Afternoon, Ms. Nestel. Sure. Happy to listen.
Mrs. R.A. sent my son in to see
As you know, I represent the victims in this case who are here today. They've been here every day filling the row. We have a special request for Monday. I don't know if it'll deviate from the court's decorum order, but if it does, we think it warrants a special decision or order from the court. And that is we're asking for the victim's family to be able to take that second and even third row during the closing arguments. Of course, nobody could or anticipate when the case was going to close or when closing arguments would be, but that's a really important day. It's an important day for the victims to exercise their right to be present, which to be meaningful means they want to hear and see as much as they can. So I think they've been very abiding to the court's decorum order. This is really important for them. There were a lot of witnesses who were subpoenaed and weren't able to come in, maybe didn't even end up testifying, but they want to come as well. So during the pretrial proceedings, the victim's family had 2 rows that they filled regularly, and there are a lot of people who loved Eric and supported him and who would like to be here that day. and to prevent people from having to camp out all night at the court's doorstep, just to make sure that they get in. Our request would be that they get the second and third row designated.
Chris, have we handed out wristbands for Monday yet?
No, sir. Our plan is to hand them out for the formal event before 0800.
So I'm just going to sound this out in real time.
Okay, listen.
What I can't do is change the rules regarding odd and even midstream based upon genuine empathy for one side or the other. But I can steal some rows back from people that do not have a familiar connection to the case. And so, Chris, it sounds like I could say rows 2 and 3 are going to be for whoever would have gotten row 2 in on whatever odd or even day Monday is, and rows 4 and 5 can be for whomever was going to get it on that day. So I can double the amount of space. I just can't switch the order.
Okay, and I think possibly the defendant's family would have been on Monday. Of course, again, we didn't know the trial was going to end, or that important day would be
Certainly neither
on
did
Monday.
I. Yeah.
If those rows are not filled, can those seats be filled?
No, it makes it very hard for court staff to manage who's sitting where and to make sure that everybody is behaving. So I got to have clear rules, but I can double the space. I mean, let's be clear. What I'd be doing is excluding the rest of the public.
Right.
But let's put it blank. Instead of 1 row for Miss Kouri Richins' family, 2 rows for the public, 1 row for Eric Richins' family, it would be 1 row for the media, 2 rows for Kouri Richins' family, and guests, and 2 rows for Eric Richins' family and guests.
Okay, thank you.
Chris, now that I've said that out loud, that's an idea. I got to make sure I did not create any trouble.
You did.
I have to deal with the public.
Well, we can send something out, right?
Yeah.
I imagine that I could ask our media partners to help me spread the word. So we'll get to that. Okay.
So I'm happy to talk
All right,
to
let me
Ms.
watch for the
Richins'
email.
family and see if they need that second row. And if they don't, I can communicate with Mr. Palmer and tell him there will be 1 row for the public.
I'm probably just going to make this decision now so there's no ambiguity so we can get ahead of it.
Okay.
So that people aren't coming to the courthouse 2 days from now with an
Okay.
expectation.
Okay.
Will you give me 5 minutes to talk to Chris to make sure I'm
Yes.
not working at cross purposes with the security plan?
Yes.
All right, let me take a 5-minute break, folks. Thank you.
All right.
Oh my goodness. Let me be proactive and send something to Tanya. I think it's a problem because the courts have to be open to the public. They have to be open to the public. The public. Hang on just 1 second. Let's see. I don't think it's going to be a verdict on Monday, though. Let's see. Hang on 1 second. Oh, my goodness. So then here's what we're saying. I'm not the family. Eric's family can take up 2 rows. Kouri's family cannot. The judge is trying to be fair and saying I could give each of you an additional row. Kouri's family is not going to take up 2 rows. They might take up 1 if they're all allowed in. Remember day 1, everyone that showed up there. That was half a row of people. Utah courts are generally required to be open to the public with a strong presumption favoring the access to both proceedings and records. This openness is grounded in the First Amendment, the Utah Constitution, open courts provision, common law traditions, and statutes like Government Records and Access and Management Act, which applies to judicial branch and presumes records are public unless specifically exempted. Utah court rules such as Utah court judicial further classify court records as public by default unless otherwise restricted. This applies to criminal trials, pretrial hearings, civil proceedings, and appellate matters, promoting transparency, fairness, and informed public decision. However, exceptions can exist where access can be limited or denied if a party demonstrates that countervailing interests, such as a defendant's right to a fair trial, privacy concerns, or ongoing investigations, we don't have that here, outweigh the presumption of openness and no reasonable alternatives to closure are available. Courts must allow specific procedures for closure, including holding hearings, making written findings, and balancing interests as outlined in cases. The judge is going to come back and say, I can't do that. The law doesn't let me close the public out. That's what he's going to say. He's back.
Counsel, this is going to be the plan for closings on Monday and the period of jury deliberations. First row, as usual, will be for members of the media with authorization to have a seat in those rows.
Those are assigned seats.
Whichever family, whether it's Eric Richins' family and guests or Kouri Richins' family and guests, is entitled under the current odd-even switching scheme to the first or to the second row. Will get the second and third. Whichever family and set of guests is entitled to the fifth will get the fifth and fourth. Keep in mind, they're going to switch each day. So if the jury keeps deliberating into Tuesday, it'll be 2 and 3 versus 4 and 5 switches. Mr. Palmer, Court Security Director, will give counsel, defendant's counsel for defendant's family and guests, state's counsel for unless you want to be the point person, Ms. Nestel, it's up to you.
I can do that just to take the burden off of them.
All right.
Yeah.
Ms. Nestel, on behalf of Eric Richins' family and guests, is going to give you 24 wristbands. And it's up to you who gets them. That'll be per day.
Thank you.
Okay? Means you got to be here, somebody from your team, and somebody, Ms. Nestel, you got to be here no later than 8 a.m. each day.
Yeah.
All right?
I'll do it.
Very good. We're all going to buy Chris Palmer chocolates and flowers because he's going to take some flack about this. I will issue an amended decorum order to make it clear this is the way we're doing things. It's the fair way to do it. To the extent you can include this in your reporting about what's coming on Monday, I'd appreciate it, just so people aren't showing up unnecessarily. Okay. All right. Anything else?
Wow.
Ms. Nestor.
No, Your Honor.
Mr. Burmester.
No, Your Honor.
Folks, I appreciate your patience. Please travel safe. Ms. Richins, I'll see you
Selena,
Monday
are there
morning.
6 rows or just 5? 1,
Courts and
2,
recess.
3,
Thank you.
4.
Grace,
I think there are only 5. Grace comes up from Court TV. Selena, I wouldn't risk it. They're asking people not to be there. I think it'll change. I don't think you can do this. Telling the public they can't come in. Here's Amber. Just 1 second. Amber, how's it going?
I have a really bad migraine, so I'm not going to stay on here.
Okay, I'm sorry.
Can we get a handle of chat, please, with the negativity and calling people out with saying that public access to the court, all of that. We don't need to be ugly in chat towards anybody that's been going to court.
Yeah, please don't. Please don't. The public access to court, we are the public. I am a huge proponent of transparency.
I'm hanging up now.
Okay, thanks, Amber. Thank you.
Love y'all.
Selena, thanks for all you do. Please don't give Selena any flack at all for this. I'm gonna to sort this out with my media contact. I believe the judge is wrong in what he just did. It sounds like, and I'll wait for the amended order to come out, but it sounds like he did close this to the public, which requires under Utah law specific hearings to be held, findings to be given, and everything. So I don't think
Call
this is gonna
from
stand.
Selena.
Okay. Hey, Selena, how's it going?
Hey, I have questions. So I was so upset, so I wasn't sure quite what they said. So no public is going to be allowed?
Currently, that's the order. No public. Through the verdict.
Well, okay.
I think it's going to change because I'm looking at Utah law, and the judge just skipped a whole big step he has to do. I realize that he's trying to help family, and that's great. I love that. I love that family wants to be there.
Oh, I thought at first he said we could have one row. Now none?
Now he's saying 2 rows, but he's giving the wristbands, 24 wristbands, which if you do the math, I don't know who that's for. He's giving it to the victim's advocate representative.
Okay.
To give those out. And so presumably she might be able to give one to a member of the public, but how you get a hold of her, I have no idea.
Okay, I'm going to do a little bit of finagling and see if I can get in. This is going to make a lot of people mad with Kouri's family.
I wouldn't, the case is over, right? The testimony's over. So all witnesses are released. At this point, it is okay to talk to people. We're not reaching out to anybody officially as a channel, but I know you've made contacts and communications with people. So do what you'd like to do there. But I don't want you to go up there thinking you're going to get in and not get in. But
well, we'll just see what happens.
All right. Let me know which way it decides to go. So
if you hear any different about him changing, will you let me know? I can't see how he can legally keep the public out, but
I agree.
Okay.
I know that's a harsh position to take when you've got family members who are losing.
And I
six to
get
members of the public.
it. I'm not trying to be mean, and I'm just trying to go anyway.
Interesting.
I know that nobody will be mad if I can't get in. It's just something that I wanted to do. I have spent so much of my time, and I'm not trying to take a family seat for Pete's sakes. I never would do that. I'm not a mean person, and I feel like I've been attacked unfairly a little bit.
I'm sorry. That was not fair. Any attack you received, that was not right. You should not be attacked at all. Let me fight this one. You obviously do whatever you want to do on yours if you're reaching out to somebody. I'm going to work with my court contact here just to clarify. Because the judge has asked us to send the message out, I'm going to get it clarified for them and just make sure they're aware what he's asking us to say.
Could I possibly be media? I know there's no way to get me a media badge at this point, but
I think she made the list for media. The assignments for seating for next week have already been made. It was made Wednesday. So
all right, it's all good.
Yep. Sorry about that. All right. Thanks a lot. Appreciate it, Selena.
Okay.
We'll see you.
Bye.
Bye. All right. I've got some work to do. Waiting for this ruling. I know there are people who are members of the media, but not officially on the media crew, not on the news media, who are attending as members of the public who are in town, who traveled in town to be there, who are now going to be excluded as well. Interesting. We'll get a message out. We'll get a message out. Are there 6 rows? Only 5. Only 5 rows. The first one's for press and 2 for each of the family. 2 for the defense and 2 for the prosecution side. There's no seating on the other side of the courtroom. It's the TV cameras and the still photographers. Yep, they've got all sorts of cables and equipment set up over there for Court TV's feed. The judge didn't say public can't attend. He, in effect, did. He said, get the message out. Use my media partners, that's us, to get the message out so people don't show up expecting to get in when they can't. 25 bands per family. You could potentially get one for a family, from a family member, which is what Selena is basically trying to do, saying, hey, if you don't use all your bands, can I have one? And I mean, that's great. If she gets in that way, I have no problem with that whatsoever. Let's see. So I'm going to be watching for an email. Is going to be on the YouTubes. Yes, we're still there. We're still here. I am officially in the media pool for this. So we've been doing months of work to line this up. We'll still have a live court feed of everything that happens. We're going to cover it from gavel to gavel. The entire deliberation time, we're going to have the feed going, so you're not going to miss a single question. You're not going to miss anything. We just would love to have a court watcher there as well. So, all right. It's still being streamed, so doesn't that count as public? Not necessarily. Not necessarily. We'll see. We'll see. Smile More Please says, Ari, you have it incorrect. Please rewind. I tell you, I was going to wait until I got the judge's decorum order, because that gets sent to me from my media partner every day. Let's see. So she's going to tell me what this is. Let's see. She has not sent it out yet. The judge still hasn't written it. 25 wristbands for public, I thought. I don't think you can fit 25 people on one row. And why is the victim's advocate giving out the wristbands? That just doesn't make sense.
Call from Selena.
Hey, Selena, how's it going?
Hey, so I have a question. Chris from Trial TV just called me.
Yeah.
And he said he understood that each of the family gets so many wristbands. Kouri's family and Eric's family.
Yeah, basically 12 people can be seated per row, a maximum of 12. The first row,
well, I can get in with. There won't be. I can get in with Kouri's family because there will not be more than 5 at the most in her family.
Yeah, that's probably the way it's going to have to go. But interesting.
I just want to be there. I've been there every day. I want to be able to still report stuff, but I don't want to get attacked by being on Kouri's side, but whatever.
No. Hey, Selena, you're great. You're great. Please ignore any haters. I appreciate very much what you've done. I've been consistent in saying that. We might not always agree on everything or see it the same way. I love what you do. I'm very appreciative that you've been in court for us.
Well, no, I don't expect anyone to see the same opinion as I am, but it really hurt when they were acting like I was thinking I was more important than the victim's family. That's what really got me. That's the only comment.
I think they misunderstood what we were looking at, because if they just said no members of the public, with 2 rows for one family, 2 rows for the other, there would be empty seats. This is not taking a seat from someone who wants to be there. That's the point.
And if you think I would step in front of them,
no, you wouldn't.
They don't know me. They don't know me, and I need to just realize that.
Yeah.
So, all right,
deep breath. You're doing great. Thank you, Selena.
I'm taking a deep breath. Okay.
We'll see you.
Bye.
Bye. All right. With that, we're going to wrap it up for today. It is 6:50. It's almost 7 o'clock, and I've got some work to do because we want to get clarified on the judge's message, and I'm going to put a message out here on my channel as well. Probably just a quick, maybe on Twitter. So, anything else?
I think I'm about to catch a whooping.
About to catch a whooping. It's time for the music, says Laura. She's calling for the music. This is going to be Laura's song in just a little bit. It's dinner time. You guys, happy Friday. We've got a long weekend. Well, not a long weekend, but it's a weekend, right? And it can go slowly, and then it will seem long. When we come back on Monday in court, we're going to have closing arguments, jury instructions, and verdict watch, which is going to be great. Thank you all for being here today. I appreciate y'all. Tonight when you go home, please hug the people you love, smile at someone. make that day just a little bit better. And please stay safe until we go live again Monday morning. I might do a little live stream just quickly, giving an update as soon as I get this from court. Just waiting for the decorum message, and we'll let you know. You guys have a wonderful weekend. You guys are amazing. Thank you all. We'll see you on Monday. Bye-bye.
Remember in the beginning when we started 110 years ago?